online seminar on the eve of International Human Rights Day today. The theme of this seminar is Criminal Justice System in India, Issues and Challenges from the Human Rights Perspective. This morning, we are very fortunate enough to have with us Honorable Justice Mrs. Sadhna Jadhav Ma'am as the chief guest and esteemed resource person for this inaugural session. We welcome you, ma'am. Let us begin today's program in the noble presence of MLNG Society's respected Dr. Kalpalata Patil Bharaswardkar ma'am, respected Principal Dr. C.M. Rao sir, who is the president of today's program, respected Vice Principal sir, Mr. Sri Krishan More, IQAC coordinator, respected Dr. Aparna Kotapalle ma'am, all the staff members, students and participants of this program. Taking forward the ongoing legacy of this institution of starting every program with the recitation as well as reading of preamble, in the online mode, I would be reading the preamble for today's session. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. On this note, we officially begin our program. Now I request respected Vice Principal Sir, Mr. Sri Krishan More, to deliver the welcome address for this inaugural session. Over to you, sir.
Thank you, ma'am. I hope I am audible.
Yes, sir.
Okay. Honorable Srimati Justice Sadhna Jadhav, ma'am, our today's honorable guest, and both the honorable resource persons, Dr. Shampadev, ma'am, Professor of Law, School of Law, Christ University, Bangalore, Honorable Advocate Dr. Rajendra Anbhule, sir, Advocate Pune, our Honorable Secretary, ma'am, Dr. Kalpalata Patil Bharaswardkar, ma'am, our respected principal, sir, who is the president of the today's function, respected all participants, we are very happy today because on 10 December 1948, the day was remarkable in the history of our humanity and humankind. Because first time by law, some juristic organization came forward and given to us all the natural human rights and duties. Dear friend, from onward, we realize that we are the human being. And for that reason, I must congratulate all of us for being a human being. And with this, I take this opportunity on behalf of our Marathwada Legal and General Education Society's MANIKCHAND PAHADE Law College, Chhatrapati Sambhajinagar, Maharashtra, on the occasion of national level online seminar organized by Avishkar Research Club on the similar theme of the human right and more particularly criminal justice system in India, issue and challenges from the human right perspective. To welcome you all the participants, particularly Honorable Justice Srimati Sadhna Jadhav ma'am, and both the guests of two sessions, Dr. Sampadev ma'am and Advocate Dr. Rajendra Anbule sir. Uh, Actually, we are eager to welcome you by the bouquet and floret, but being we are gathering here on online mode, so we will welcome you by this very good uh, welcome message on behalf of our Marathwada Legal and General Education Society Management, our MANIKCHAND PAHADE Law College principal, teaching and non-teaching staff, and all the student fraternity of college. I welcome you, honorable guest, and all the honorable participant who are joining from throughout the nation to this very important national seminar we are going to organize online mode. And I'll not take much of your time, but only I can remember here the one of the very important development which was taken place in India before 56 year of the Human Right Declaration formally. The very first word of the Human Right Declaration, first line, first article says that all men and women are by birth independent and equally entitled for all human rights. The similar thought was given in India by Mahatma Phule in his Universal Religion of Truth, and he had given the same statement in his first rule of his universal religion, says that all men and women are equal by birth and are entitled for all due human rights. Actually, we have very good history of the human rights in India before Mahatma Phule also, and we have the thread of this human right history, human right approach, and we have very good Honorable Justice Jadhav ma'am, particularly who has very good contribution through her different kind of the judgment while delivering the criminal justice. And I hope in the today's lecture also, ma'am is going to talk on and guide us on the similar thought. Also, the both guests uh, have good academic on that, and I welcome you all for this August gathering. I am thankful to you, Miss Amrita ma'am, for giving me this opportunity to welcome formally all our guests. Thank you very much.
Thank you so much, sir. Now I request Dr. Aparna Kotapalle ma'am, QC coordinator, to introduce us all about this national level online seminar which is organized today by Avishkar Research Club of our institution. Over to you, ma'am.
मैडम आवाज नहीं आ रही.
Not audible, ma'am.
Am I audible now?
Yes, ma'am.
Yes.
So, Honorable Justice Shrimati Sadhana Jadhav, ma'am, the chief guest of today's event, and Dr. C.M. Rao, sir, who is the president of this today's inaugural session. Honorable Dr. Kalpalata Patil Bharaswadkar, madam, Secretary ML&GE Society, Vice Principal More, sir, and all the participants of this national level online seminar on the criminal justice system and from the perspectives of human rights. I welcome you again in this August gathering. Let me first of all give you the best wishes on the Human Rights Day. The historical perspectives have been communicated by More sir while giving the welcome address. But then the duty is lying on me to communicate you about this seminar, and the journey basically starts with the establishment of Avishkar Research Club. I need to communicate it to you all because you all have gathered here from different states of India. I'm very happy to share in the beginning that more than 140 participants have registered from Kashmir to Kanyakumari in real sense. There are faculty members, there are students, there are advocates, and not only that, from NGOs also, engineers and other people, they also have joined this seminar, and we feel happy for the same. Basically, this research club was the innovative practice of the institute. The journey of the research club began informally in the year 2009, but formally in the year 2010. I won't be discussing much about all the activities of the research club, but it is very must to communicate since beginning, since inception, that is from 2010 onwards, each year, Avishkar Research Club organizes one or the other event on the eve of Human Rights Day. Basically, we initiated the practice of celebrating this day so as to inculcate the sensitivity in the mind of students, so as to create awareness in the minds of students from the journey that was initiated from the intra-college activities. I feel happy, privileged, and proud to communicate that for last 10 years, we traveled a lot. That went on with the state level activities, with the national level activities. And Avishkar Research Club also have conducted international conference on human rights during COVID period. So we feel happy, MP Law College feels happy that every year we are creating sensitivity, we are creating awareness about the human rights. This year, we planned to have the seminar on criminal justice system, but the examinations were scheduled and hence we had to shift on online mode. Whether to go with the seminar right now, whether to postpone it, we were in dilemma. But we decided to go with the online mode. Maybe all people throughout the country would be able to participate. So though there are certain negativities that are involved in the online mode, which we understand, but still we take it in a positive way that maybe otherwise people might not have been, it would not have been possible for the people in India in such a large scale to join with us, and now they are joining with us. So taking it in positive ways, this online national level seminar is being organized on a theme of criminal justice system, which now is categorized in 3 sessions. Apart from the inaugural session, there are 2 more sessions. One session is would be dealing with the fundamental areas, foundational areas, jurisprudential areas, theoretical perspectives, on which Honorable Dr. Shampa Dev, who is a professor of law in Christ University, she would be guiding us. In the second session, it is Advocate Dr. Rajendra Anbule, who would be dealing with the theme role of advocates in protecting human rights. As we all know that human rights, when we talk of criminal justice system and human rights, it is not only the victims, many times it is the human rights of accused also, and hence, and of course there are many stakeholders that are involved apart from even advocates and honorable judiciary. It is investigative mechanism. We were trying to have one session even on that, but maybe some other time we consider that there is a scope of improvement from our side, and let me begin with that we have a clear understanding about it in the beginning. We feel fortunate enough that now for the inaugural session we have Honorable Justice Srimati Sadhana Jadhav ma'am, who is not known only for her judgments, but during whole career of her advocacy, she has spent many years in the criminal justice system. Ma'am, we are really, really thankful to you for accepting our invitation and being present amongst us to guide us on this occasion of inaugural session. I thank the organizers for giving me this opportunity to introduce this event. Thank you one and all. Jai Hind. Thank you. Over to you, Amruta.
Thank you so much, ma'am. Now I take this opportunity to introduce our chief guest and resource person for this inaugural session, Honorable Justice Mrs. Sadhana Jadhav, ma'am. Ma'am is currently working as a member of Maharashtra Legal Services Authority and is designated as Senior Counsel of the Honorable Supreme Court of India. Honorable Justice Sadhna Jadhav is a renowned judge of the Bombay High Court, Maharashtra, and has been the judge in a number of notable cases concerning criminal offences, including the death of Sheena Bora, the Adarsh Housing Society scam, trial of Bollywood actor Sanjay Dutt, and so on. Ma'am has heard appeals filed by several members of the Sanatan Sanstha and Hindu extremist group in connection with the widely reported murder of writer Govind Pansare. Ma'am has her major practice in the criminal side and has appeared as a special counsel for various PSUs, Airport Authority of India Limited, Cement Corporation of India, Hindustan Petroleum Corporation, and many more. So, ma'am has come to this journey of law, starting her career from the Symbiosis Law School, Pune. Initially practicing law at the Aurangabad bench of Bombay High Court before practicing in Mumbai. Ma'am was also appointed as an additional judge of the Bombay High Court on 23rd January 2012 and has continued to sit on the bench till 13th June 2022. Ma'am is also responsible for several legally significant interpretations of criminal law and procedure. These are concerning the right to appeal and regarding penalties under the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989. Ma'am has also delivered a landmark case judgment that has come in the appeal against conviction and death sentence confirmation of accused in the Shakti Mills gang rape case. Also, there is very remarkable contribution by Madam when she was working in the Honorable Judiciary during the COVID-19 pandemic period. Ma'am had a disposal of 18,694 cases, of which 16,059 were criminal cases and the rest were civil cases. Ma'am has also disposed of 8 death penalty cases in 3 months, which were pending for around 8 long years. Ma'am has very recently also given a training program to the judges from Myanmar at National Judicial Academy, Bhopal, and was also the chairman of Pre-Litigation Center, a part of the committee which opened 9 pre-litigation centers in Maharashtra. Ma'am was also heading the High Court Committee for Juvenile Justice for the state of Maharashtra and has introduced innovative steps for the upliftment of juveniles in conflict with law. This is a very brief introduction of Madam, but being a very socially active person, I would like to take this opportunity to congratulate all of us that we have Ma'am with us today, as she has worked in the field of human rights by her contributions, and we are very fortunate enough, Ma'am. So once again, we welcome you all to this program, Ma'am, and I request you to kindly deliver the inaugural session address. Over to you, Ma'am.
Good morning, one and all. Good morning, Secretary Mrs. Kalpalata Patil Bharaswadkar, Dr. Aparna Kotapalle, and all the co-hosts, as well as the members who have joined this meeting. Today, we all should congratulate each other for celebrating the 75th anniversary of the United Nations Declaration of Human Rights. Today, after my introduction, I would like to say something that I'm not here to give a speech or an address, but today is the time that we talk to each other, apprise each other of not only just the criminal justice system, but what the judiciary has done for the criminal justice system and to protect the human rights which are enforceable by our constitution. After all, what do we understand by human rights? Human rights or human being is not just a mass of body. It means a life with dignity, a life which has fundamental rights as a human being, and a life which recognizes the dignity of a human being. And all this can be secured only and only if we respect each other as human beings. There was a time when the society in general missed all this. And that is precisely the reason why the United Nations intervened. And today we are celebrating the 75th anniversary of the Human Rights Day. We are speaking of criminal justice system. The first fundamental principle, as we all know, of jurisprudence is that no one is presumed to be guilty unless the offense is proved by a court of law. And this is the fundamentals of criminal jurisprudence. But the question is, what are the rights of the accused also? While practicing on the criminal side, many a times, I may be knowing that maybe this offense has been committed by this particular person. But as an advocate, did I have a right to presume that he is guilty? I was a defense lawyer, and naturally I presumed that yes, he has a right to be defended, and I would leave it to the court to decide on the basis of the evidence as to what is the offense committed. And many a times at the end of the arguments, I myself would say that he be punished in accordance with law, and the punishment shall be proportionate to the offense committed by the accused. Today we have many advocates who have joined this symposium, and I would request all of them that this should be the temperament of an advocate, not to presume. Of course, there are certain acts which contemplate that there shall be a presumption of guilt, and that is POCSO. Or then it is a rebuttable presumption. So instead of just going into criminal justice system, what we are here to see today, what is the contribution of the court in protecting the human rights while dealing with the criminal justice? I will not go into the cases of A.K. Gopalan, D.K. Basu, Neelabati Behra, Unni Krishnan. All these cases are known to all of you. And the Supreme Court has spoken for this society as a whole. Recently, if you see in the case of Arnesh Kumar, when the Supreme Court realized that yes, there has been a misuse of the provisions of Section 498A, the Supreme Court intervened, and what was introduced or what the amendment came about later was Section 41A of the CRPC. And therefore, the accused would not be arrested without giving a notice, without being convinced that he has really committed an offense. And this is one of the greatest contribution of the Supreme Court. Now, what we see is, while delivering justice on the criminal side, it's not just the proportionate punishment to the accused, but justice to the victim also. While deciding the case of the Shakti Mills gang rape case, I was to decide Section 376E of the Indian Penal Code. That was the latest amendment. And as you all know, in Maharashtra, that was the first death penalty given by the Sessions Court. So the question before me was whether death penalty is mandatory in such a case. And while dealing with the case, the facts revealed that yes, it needs a consideration, because even the Law Commission had specifically said that 376E does not mandate death penalty. But the question was to do justice to the victim also. She's alive. And what I realized was she's going to live with that guilt which she has not committed. She is going to live the trauma throughout her life. And therefore, the sentence of death penalty was converted to imprisonment for life. But life means life. And that the accused would not be entitled to any parole or furlough, as they did not deserve to assimilate with the society. I feel that death penalty is not the only sentence which can be imposed. But at the same time, you see how the inconsistencies go. On the same day, I delivered another judgment in which I gave death penalty. So would a judge be inconsistent with herself while awarding death penalty on the same day at the same time? No, because the case contemplated rape and murder of a 3.5-year-old girl child. And the question before the court was whether a small girl of 3.5-year-old would even provoke a person who is the father of 4 daughters. And therefore, death penalty was given. So now the question is, what are the human rights? Whether the same right could be extended to the other accused. No, in the facts of the case, no. We have several such cases. As on today, even the Supreme Court has said that no, the sentence of death penalty is not the only sentence that can be awarded in such cases. The latest contribution of the Supreme Court would be the case in Manipur, where the Supreme Court intervened to form a committee of renowned judges. One of them is the retired judge of our own High Court, of Bombay High Court, that is Justice Shalini Phansalkar Joshi. And they are there to see how they can be, how the victims, the survivors of that Manipur case can be considered in accordance with law, and by giving them dignity once again and compensating them. But no compensation can be sufficient for protecting the human rights. So these are some of the experiences that I have. But today, let us discuss something more. Apart from criminal justice, what is the contribution of the judiciary to protect human rights? I have practiced at Aurangabad High Court, and I'm proud of my bench. I would just remind all of you that on 30th of September 1993, there was an earthquake at Killari in Latur district. At that time, the administrative judge of the Aurangabad bench, Justice B.N. Deshmukh, who is no more with us, we all had seen tears in his eyes when he was on the dais. He just rose at about 11 o'clock, took some lawyers from that area, and he himself visited the district. He went to Killari, he traveled in the Latur district, and he saw to it that there is some solace to the victims of the earthquake. Justice B.N. Deshmukh just did not stop at this, but we had registrar, later on Justice M.G. Gaikwad, who was appointed as a special officer on duty. He was sent deputed to Latur to stay there and observe and supervise all the provisions made by the government. The government had taken a lot of efforts. But at the same time, there was judicial intervention. There was monitoring, there was supervision by the Aurangabad bench. And thereafter started the era of public interest litigation. Our bench was open to all the victims of the earthquake. I have myself witnessed that there used to be ladies who used to approach the court directly as parties in person and inform the court that the government is not doing enough. And the bench used to consider their grievances. And thereafter, the solace was given by directing the government to make provisions for the victims of earthquake at Killari. This is how the sensitivity of the court to protect human rights, even of the people who are not before them as plaintiff, defendant, accused, complainant, nothing. This was social intervention. Then we come to the Right to Food Act of 2013. If you all remember, 47 people from Rajasthan had died due to starvation as a result of 3 consecutive years of drought. The Supreme Court took cognizance of the same and directed the government to make special arrangements so as to lift all the food stock from the central government and see to it that it is distributed amongst the people of not just Rajasthan, but wherever there was drought. This was in 2001. A commission was appointed by the Supreme Court, and the supervision was done as to whether these drought affected people were given the food or not. The most important movement at this time was led by the People's Union for Civil Liberties. That is, we all know, it is mostly known as the Protection of Food case and registered under the PUCL. It was they who had approached the Supreme Court. And due to the intervention of Supreme Court, in 2013, the Right to Food Act was brought in by the legislature. Unfortunately, the case had to be disposed of without passing a judgment, as the Supreme Court observed that in view of the monitoring system of and the commission's work, the government has already brought about the 2013 Act, and there is no need to give an order, and the case would stand disposed of. In the meanwhile, what we had was the right to education. These are some of the rights given to the human beings by the Convention of the United Nations under the Human Rights Act. The right to education. All citizens are entitled to education was one of the directive principles as you all know. But then the time had come to make it a fundamental right so as it could be enforceable by the courts of law. And therefore, even before the Food Act came in 2013, in 2009, we had the Right to Education Act. These are some of the interventions by the Supreme Court. And I'm proud that the judiciary has stood strong to protect the human rights. Then further, we come to the other acts which were the result of the intervention of the Supreme Court. One of the right was, which was, as I said earlier, the right of not to be arrested, which came in the case of Arnesh Kumar. Thereafter, we come to the Morbi case, the downfall of that bridge where several people died and several people were injured. It was the Gujarat High Court which then intervened and almost dissolved the municipal corporation of Morbi and took to supervision of that entire monitoring the whole process as to how the families of the dead could be compensated for what has happened, and an inquiry was initiated. We then come, these are some of the latest cases that we are just discussing. Then we come to the rights of the sugarcane cutters, women sugarcane cutters from District Bid. If you all know that it was the Bombay High Court and the present Chief Justice of the Madras High Court was sensitive enough to take cognizance of a newspaper cutting and had initiated a suo motu writ petition to inquire into the same, where the sugarcane cutters, women sugarcane cutters of District Bid were just to protect their daily wages. What the women used to do is get operated, and there was the removal of the uterus. The case is pending, and it would not be proper to discuss as to what are the steps taken by the government or the case which is being led by renowned lawyers. Yes? Is there some difficulty? Yes?
No, madam, go ahead.
Okay. I thought I was not being audible.
It's audible, ma'am.
Okay.
You're audible, ma'am.
Okay. It so happens that we are still not very net savvy, to be on, to be with an online talks. So while discussing all these cases, I am reminded of the great contribution of none other than Mahatma Gandhi, Jyotiba Phule, as Dr. More has discussed. So today, while discussing the theme of criminal justice and human rights, it can be put in one line. And that one line is, an accused is a human being and he has all fundamental rights. And just because there are accusations against him, you cannot say that he deserves or he has been deprived of all his fundamental rights. That is not the way we go on. And that is what is recognized by the courts of law. Am I audible?
Yes, ma'am.
Yes, ma'am, you are audible. The
Yes, ma'am,
instructions
you are
are for
audible, ma'am.
participants.
Yes, yes. So there was a little
Ma'am.
bit of disturbance. Yes. So today we are discussing all these things only to celebrate. And in India, what we are trying to celebrate is the protection of our preamble. Today you may see that I'm traveling across and I'm saying that sometimes criminal justice or the intervention of the court, but we cannot discuss only about criminals. We are discussing about the victims also. And when we are discussing about the victims, we cannot forget some of the cases which have come before the court where priority is given to the victim and not to the accused. It's not always the defense. Even if the prosecution has not proved the case or is not appealing properly, there have been several cases where the court has suo motu issued notice of enhancement. And one of such case comes from Aurangabad. That is the case of Sanjay Rajan, where he was given life sentence, but it was the High Court which had issued notice of enhancement, and therefore he had to defend himself as to how it could not have been a case of death penalty or even life imprisonment. The judgment of the High Court is confirmed by the Supreme Court, and you all can go through it. Mahatma Gandhi, Martin Luther King Jr., the Nobel Peace Prize winner of 1964. All these people have contributed to our thoughts today. Non-violence, empathy for others. This is what is the core, the nucleus of the human rights. Let me tell you about one case which had come before me. As you all know, the Protection of Scheduled Caste and Scheduled Tribes Atrocities Act, that was brought about only for maintaining the dignity of the people who belonged to scheduled caste, and they needed to be assimilated with the society, and they deserved the same dignity like others, and they could not have been treated separately. So there was one case which had come up before me, and the case was that a teacher had insulted, humiliated in a meeting a member belonging to scheduled caste in a very bad manner, in an abusive manner. So naturally, as you all know, since anticipatory bail is not provided for, not contemplated, it was the accused who had come before me and seeking the quashing of the FIR, but there was no question of quashing of the FIR. So as an interim measure, I had directed that he would be protected by way of pre-arrest bail, but for 8 weeks, he had to go to Buddha Vihar and he had to teach the teachings of Dr. Baba Saheb Ambedkar in Buddha Vihar, and that too on every Sunday. And this was to be monitored by the investigating officer. It was criticized, but at the end of 8 weeks, the accused appeared before the court, and the advocate for the accused was kind enough to tell me that it was the opinion of the accused that it was the first time even he read the writings of Dr. Baba Saheb Ambedkar, and he took a pleasure in teaching those people who really did not know what was Dr. Ambedkar. They were the followers, but they did not know the teachings of Dr. Ambedkar. And thereafter, this accused continued to teach them for almost 6 months. In fact, it was very easy to punish this man for abusing a member belonging to the scheduled caste and scheduled tribes. But no, the question was, he needed to be given a lesson. He needed to be told that it is not just punishment, but he should learn to respect the members of the scheduled caste. And unless he does that, he would not bring about peace and harmony in the communal system. So after all, human rights is also, the protection of human rights is also to maintain peace and harmony in the community, in the state. And that even amongst the states, with other countries, and all this can be brought about even by an international a treaty amongst the countries. What is it we are talking about? The ways and means to protect the human rights. I don't know how many of you remember the case of Shanbag, where she had pleaded that she does not wish to live anymore. And at that time, the Supreme Court intervened. You all know the result. The result is that because of Shanbag, the Right to Life Act has come into existence. Every human being now, the citizen of India, can make a will as to what he expects when he is on the deathbed. It is not suicide, but you all may please read what is the right to life, and you would read the judgment of Justice Khanwilkar, where he says that yes, you can make a will on how you wish to live the life and how it should end. So these are some of the judicial interventions. How criminal justice system has to. Yes.
Dear participants, please don't create any kind of inconvenience by keeping your sound system on. Sorry for the inconvenience, ma'am. Please continue.
No, it is not. It is not inconvenience, but I'm just a little bit disturbed with all this. When I hear something, I feel someone has to ask a question or something, and that is why I stopped. Is there anything like this?
Nothing.
Okay. Okay. Dr. Rao, sorry. Sorry for the.
No, not at all a problem. Go ahead.
Okay. So, therefore, respect for each other, protecting the fundamental rights of each other would bring about peace and harmony in the society. And that is all what I think. If we understand this, we would be achieving the whole object of the United Nations Convention and the grant of human rights to all of us. I would thank Dr. Aparna Kotapalli for giving me this opportunity to address all of you. I'm sorry for the inconvenience, if any. And I wish you all once again on this eve of celebration of the International Human Rights Day. And I take your leave and leave it to Dr. C.M. Rao, to Dr. Aparna Kotapalli, to Dr. Marathwada, and all others.
Thank you. Thank you so much.
Thank you, ma'am. Thank you so much for your enlightening words. You have guided us a lot with your experience and your practical examples as well. We are really enlightened, ma'am. Thank you so much once again on behalf of all the participants of this seminar. Now, I request the president of today's program, our respected principal, Dr. C.M. Rao, sir, to deliver the presidential address of this session. Over to you, sir.
Honorable Justice Srimati Sadhana Jadhav Madam, Honorable Secretary Dr. Kalpalata Parswarkar Patil Madam, Aparna Kottapalli, convener of the Avishkar Club on today's gathering. It gives me immense pleasure to say a few words which refreshed my memory while Madam is delivering examples of SC atrocities case. There is one case which was happened in Chennai when I am working in Chennai, where the judge asked the particular person to go to Gandhi Mani Mandapam, go there and be there for 1 month, read everything which is the writings of Gandhiji to reduce the temper or anger in the particular accused. So there are several occasions in the judiciary where we can see that type of approach by the judiciary to remove the anger in the particular accused while they are doing an offense. This is one example. The second thing which I would like to say is another thing is there are two sides of the coin while delivering the justice. Justice delayed is justice denied. At the same time, justice hurried is justice buried. So on the point of the victims, we see that justice delayed is justice denied. But when you are going to be hurried, justice is buried on the point of victims. Both the coins, both sides of the coin was, Madam, expressed through various judgments by citing various examples. So being a human being is a God's gift, but living as a human being is not that much easy when compared to born as a human being. There are some people who are living, but they are dead because of their attitudes. But there are some people who, even though we are not seeing them, just our vice principal quoted Mahatma Phule, Ambedkar, Gandhiji. These are the people who are living because of their humanity, which was remembered not only in India, all over the world, because of their contribution for the humanity. If you do good for the others, everybody do good to you. If you people are thinking hatred or towards others, the hatred will come to you in one way or other. And always keep human is not that much easy. The well-being of others is not much that easy, and egos in the human being is the main problem. When you wipe out that egos and mingle with all the people as your brothers and sisters, the fraternity, what we recite in the first preamble, fraternity among all the human beings, is considered to be the best solution for all the rifts between the society living people. So with this, I thank the organizers for giving me opportunity to express my views on this particular 71st International Human Rights Day. Thank you. Thank you, madam.
Thank you so much, sir. Thank you, sir. Now, we also have a question and answer session, ma'am. So, can we take up some queries of the participants?
Yes, very much.
Okay, ma'am. I request all the participants of the seminar to either, yes, they will have to post it in the chat box. Accordingly, we can have an interactive question and answer session now with ma'am. Actually, there is already one query in the chat box.
Yes, you can read it out.
Okay, thank you. As we celebrate 75 years of UDHR, How do you think the human rights should be better protected on ground when the international community is witnessing two wars or humanitarian crises?
Palestine and yes.
Yes, Russia, Ukraine, with a lot of atrocities and human rights violations.
See,
Going
my answer would be that standing for the victims, standing for the underprivileged, standing for others, that would be the achievement of the Human Rights Convention. Today, even speaking for the people of Palestine, standing for them, that is why I gave the example of Martin Luther King Jr., where it was because of his efforts that we have been, that the Americans have got their civil rights, right from the right to vote. So this is something only by standing with each other. See, protection of human rights is not something which one individual has to do. It is a social movement. That is why I gave the example of People's Union for Civil Liberties. When they approached the Supreme Court for right to food, right to education, it was a social movement. It was not one individual. And that is the only way we all have to join hands with each other and stand for the victims of war.
Ma'am, thank you so much. The next query is from Mrugasharao Deo. What, if any, accused committed rigorous crime and how that can be ignored as punishment is lessened to society? Will it mislead for ideology?
No, 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 no. There is no question of ideology. And that is precisely, see, therefore, my opening statement was that the punishment has to be necessarily proportionate to the offense committed. And that is how that would give a clear signal to the society that we cannot get over. Our criminal justice system is very strong, especially in India. And nobody can be let out. Of course, it is the duty of the state. And I would not say much as to how the executive should do this duty. The legislators are taking care. And if you have seen the latest amendments to the Criminal Procedure Code, you will see that forensics, they have concentrated so much on forensic that necessarily with the investigating team, there has to be monitoring, the doctors have to be present. All this is being taken care of. But I don't think that it must be the rarest of rare case where someone is simply let out. And that is why we give the example of Manipur. They were arrested almost 60 days thereafter. And looking at the social media, the Supreme Court intervened, formed a committee, and you will see now we don't have much on social media about any offenses being continued in Manipur. Today, the social media is very influential. So don't be under the impression that we will change the ideology or we are giving any wrong signal to the society. And you, if you are a lawyer, it's for you to stand up for everyone.
Thank you, ma'am. Next query from Amulya Raj. Are some people naturally bad, or does their upbringing and environment lead them to commit crimes according to your experience?
See, according to my experience, no child is born as an offender or as an accused. No child is a criminal at birth. And therefore, the right word is accused. Why? Because certain accusations are made against him. And yes, you are right. It is most of the times we see the environment. What I have seen is the environment, the poverty, to belong to a class of underprivileged. This is all makes a person an offender of law. When I was dealing with the juvenile offenders in conflict with law, many a times we saw these boys were extremely intelligent, but the background from which they came was not very cohesive with the society which we are thinking of today. And that is why, especially now, see, there are offenses against women. Why is there a rise in offenses against women? Mainly because in the childhood, the boys have never been taught to respect a woman. What they have been seeing in most of the cases, the children have seen the father abusing the mother day in and day out. And therefore, that impression that a woman is just an object. And that is why there is rise in these offenses. And therefore, it is the duty of the society, the legislature to see, to make the curriculum in such a way that they are taught how to respect women. So therefore, it is always the environment or the class to which they belong, or when they are fed with wrong ideologies, ideologies which do not recognize the fundamental rights of the other person in the society. And today that is very rampant. Today, when we are not respecting each other's religion, that is also seeing the uprise in the offenses that are committed. Just because you belong to an ideology, it doesn't mean the other ideology is bad. And this I'm referring to religion. So it becomes our fundamental right to recognize the religious rights of the others in the society. It's my firm opinion, and especially when I was a defense lawyer, I would always say that no child is born a criminal.
Absolutely. Thank you, ma'am. Next query from Shraddha Kapadne. How would you, just a minute, ma'am. How would you look at the scenario of quick justice system emerging nowadays on the occasion of Human Rights Day?
There cannot be a quick justice, let me tell you, because I believe in justice hurried is justice buried. What is this quick justice system? I will remind you of the rape case in Andhra Pradesh, where the accused were shot dead within 5 to 6 days after the ghastly incident. And the officer who did it was being felicitated so much that people were even thinking of introducing, I think, what is called the Shakti Bill. Is it, Dr. Kotapalle? The Shakti.
Yes, ma'am.
Yeah,
Disha,
Shakti
Disha.
Bill.
No, Disha
Yes.
bill, madam. Disha bill.
Shakti Bill is in Maharashtra, sir. Shakti Bill.
Andhra,
Shakti bill.
Disha bill. Andhra
Yes.
is Disha bill.
Yes.
Okay. Yes. Thank you, Dr. Ram. So there cannot be quick justice system. Now, as far as India is concerned, just imagine, we have spent more than 2 years in the trial of the Kasab's case. He was given all the fundamental rights, although he was in a cellular jail. His food was being taken care of, his health was being taken care of, he was given defense lawyers. We all are aware of the tantrums he had thrown. He had raised an issue that he is a juvenile in conflict with law. And we have heard all of that. We gave him sufficient time. So there is no question of quick justice. We must give justice in accordance with law. And that is the only thing that a human rights day on which we should remember and celebrate.
Thank you, ma'am. Next query from Kailash Chafale. Right to speedy trial is now fundamental right enshrined under Article 21. My question that is, this right is enforceable or not? Maybe you want to
Yes, it is very much enforceable. And now I would tell you, let us restrict ourselves to the state of Maharashtra when I'm coming here. The Legal Services Authority, we give legal aid to all the accused who are not being represented. See, this reminds me of a case at Aurangabad bench where a person was given death penalty. His appeal was being heard by a division bench, and in the midst of the appeal, it was the counsel for the accused who pointed out that the person who was appointed through legal aid, his practice was hardly of 2.5 years, and that he could not have defended the accused in a proper manner due to lack of experience. Let me tell you, the bench had remanded the matter back to see that he is given proper representation at the sessions court, and then the matter had come up again in appeal. So in all cases, we give legal aid. So much so now that I will tell you, in district Nasik, our Secretary of Legal Services Authority, Mr. Indalkar, he took the help of the paralegal volunteers, and they were sent to Nasik Central Prison. They had made a survey as to how many accused are there who are not being represented. A data was submitted to the Legal Services Authority, and it was noticed that some of the people had served their sentence, and it was never brought to the notice of the court due to lack of representation. And they were all given representation, even for conducting appeals. And therefore, the Legal Services Authority ensures that this right is enforceable.
Thank you, ma'am. Now, due to some paucity of time, we will be concluding the question and answer session. As of now, we will be taking it. If
Yes,
possible.
because I saw someone asking on unemployment.
Yes, ma'am. So, we will be conclude with the question and answer session as of now, ma'am, with your
Yes.
permission. Thank you, ma'am. Now,
Thank you so much.
Yeah, thank you. I request Ms. Chinmay Deshpande, ma'am, to propose the vote of thanks for this session.
Amrita, am I audible?
Yes, ma'am, you can.
Okay, thanks. Good morning to everyone. I, Chinmay Deshpande, Faculty of Law, take this opportunity to propose vote of thanks. It has been an honor to be a part of this wonderful session. Gratitude is not in the words but in the heart which expresses it. So with this, I express my profound gratitude to today's chief guest, Honorable Srimati Justice Sadhana Jadhav Madam. Today, ma'am has enlightened us with her valuable words. Thank you so much, ma'am, for your presence and giving us your valuable time today on the eve of International Human Rights Day. Most humbly, I thank the President of MLNGE Society, Mr. Vasadikar sir. I thank the Vice President, Senior Counsel Advocate Sri Rajendra Deshmukh sir, and I thank the Secretary of the MLNGE Society, Advocate Mrs. Kalpalata Patil Bharaswadkar Madam, for their constant support and encouragement. I express my deep thanks to our dear Principal Sir, Dr. C.M. Rao, for presiding over the session and his presidential address. My thanks to our respected Vice Principal, Mr. More Sir, for his welcome address. My thanks to our IQAC coordinator, Dr. Aparna Kottapalle ma'am, for organizing this event and for introducing the seminar. I would like to thank the august gathering without whose presence this program would not have been possible. I would like to extend my thanks to Ms. Amrita Johar, Faculty of Law, for anchoring the inaugural session. Lastly, I would like to thank the organizers for giving me this opportunity. Thank you.
Thank you, Ms. Chinmay, ma'am. Now, with this vote of thanks, I mark as concluded the inaugural session for this national level online seminar. And I request Ms. Uma Shinde, ma'am, to take over for the next upcoming session. Thank you so much, ma'am, once again.
Thank you, ma'am. Thank you so much.
We solicit your physical presence whenever you come to Aurangabad, madam.
Ram, thank you for the invitation. I just wanted to say that today I was a bit uncomfortable. That's all. We are not yet much used to all this online sessions.
Good response from all the participants. Comments.
Okay, thank you.
Okay. Uma Shinde. Where is Uma?
Miss Uma Shinde, I request you to please take.
Unmute from host side.
Go ahead.
Thank you, Amrita. With the permission of Dr. Sampadev ma'am and Dr. Principal Rao sir, should I go ahead with the second session?
Go ahead. Go ahead.
Thank you, sir. I, Uma Shinde, faculty of MP Law College, welcome you all in this today's second session program. In the second session, we have with us a resource person, Dr. Sampadev ma'am. Before starting with this session, I would like to give brief introduction of Dr. Sampadev ma'am. Ma'am has completed her Bachelor's of Law from Nagpur University. She did her Master's in Constitutional Law and Administrative Law from Nagpur University. Ma'am awarded with PhD degree in the year of 2013 from Dr. Babasaheb Ambedkar, Marathwada University, Aurangabad. Under the eminent guidance of ma'am, 5 research scholars are doing their PhDs. She has also completed 8 certificate courses from different universities like University of California, University of Amsterdam, University of London, University of Auckland. With this, ma'am has also published several articles and several research papers in a very reputed journals. Her research interest areas are constitutional law, gender justice, environmental justice, right to privacy, disability rights, and human rights. Ma'am has also attended and presented several papers and conferences in jurisprudential framework to address legal issues of contemporary significance. Ma'am has also been invited as a resource person in different programs for refresher course in law on exploring jurisprudential foundations of rights and in faculty development program with respect to outcome-based legal education, designing course outcomes, program outcomes, and alignment of andragogy and assessment toward those outcomes. Ma'am is having 19 years of teaching experience, and I feel proud to tell that ma'am was assistant professor in our institute in the year of 2005 to 2012. Presently, ma'am is working as professor and program coordinator in School of Law, Christ University, Bangalore. I heartily welcome you, ma'am, for this today's program and request you to kindly enlighten with us. Before we proceed, I would request to all the participants to put all their queries in chat box. Those queries will be dealt after ma'am's session, and please mute yourself. Over to you, ma'am.
Thank you so much. I have a PPT to share. May I do that? Will I be able to see the chat box? Yeah, thank you so much. Shall I start there?
Yes, ma'am.
Okay. A very good morning to one and all present here. And yes, once again, it's a happy thing to be with all of you half of my mind is there on many occasions. I keep thinking about all of you over there at MP Law College. It was such a nice time I had over there. Even today, the morning session, the Sadhana Jadhav madam, it was really awesome that ma'am covered comprehensively almost every aspect of human rights, every human rights aspect of criminal law and criminal justice system. And the questions here, some of them are very intriguing, like the foundational questions. And I hope I'll be able to touch upon some of those, because I know it's such a vast, big topic, and within a small span of time to cover all of that is really going to be difficult. And some of them are such foundational questions that they do not have immediate answers. Now, and for that, at least what we could do, what I aim to do through this session is to just bring those questions to light. And even if we can ponder over it for some length of time, we would have done some justice to the day, the special day that it is, that's the Human Rights Day. And this, by virtue of the fact, as Mori sir at the start said, that we are privileged, we are born as human beings. And today we also have, we had to have a mention of Human Rights Day, primarily also telling us that there's some problem by virtue of which we had to come up with a Universal Declaration of Human Rights. So frictions have been many, and being human beings, and that too emotional beings, sentient beings, belonging to certain groups, we identify ourselves with our own groups or our own communities and treat the other communities as different from us. That leads to more and more friction in the society. And today is the day to ponder upon all of that and see whether we could make more sense of our lives, of our societies, and how we have brought these societies up, and whether there needs some fundamental change to be, having a better life, a good life, and what would be that common good. And towards that, I have divided my session into primarily two questions, because what I thought was, dealing with everything, human rights, foundations of criminal law, I may not be able to do justice. So I'll focus on two main things, and that one is about torture, and the second one is about privacy, the most recent discussions around it. And I'm going to look at the foundations of that and how criminal justice system can be built, and we will have some discussions. I would love if you would put your responses in the chat box to the questions that I keep putting across to you occasionally, right? So we started a good note from Mother Teresa, and we all know that. You would have read this now. Okay, so first and foremost, do we all support the cause of human rights? You can put your answers in the chat box. I do not think that anybody would say no to that. Aparna, would you like to say something? I think you've raised your hand.
It was for the support of a human rights cause. That's it. As you highlighted.
Okay. So do we all support the cause of human rights? I do not think anybody would say no to that, right? Yeah, that's a full support. And by human rights, what do we mean? Does India have a document for human rights? The International Document Day is what we are celebrating today. The Universal Declaration of Human Rights that was passed in 1948 on 10th December 1948, and this 10th December is observed as the Human Rights Day. But what about India? Do we have a separate document for human rights? To live a dignified life is a right of every person. Yes. If we look at the Indian Constitution, we find that most of our fundamental rights are designed around the Universal Declaration of Human Rights articles that are there. We have the Constitution, yes. And that's what even I was telling, that we do have the fundamental rights chapter. But if you see that UDHR has 30 articles in it, and we have a lesser number of fundamental rights. And we kept on saying that we have all our human rights through the fundamental rights document. But then we did have huge lot of human rights violations. Even today there are, but we did have a lot of human rights violations happening, and a criticism from all over the world that India does not even have a human rights commission or a body to protect and promote human rights. And eventually we passed the Protection of Human Rights Act in the year 1993. Thank you, Dr. Amit Singh, for that answer over there. So we drafted up a Protection of Human Rights Act in 1993. And here we gave the definition of what our human rights are. And if you look at the definition of human rights in this Protection of Human Rights Act, you go to section 2, and it says that unless the context otherwise requires, human rights would mean rights with respect to, and it goes back to the fundamental rights chapter, wherein it talks about life, liberty, equality, and dignity. So all the rights that we have with respect to life, liberty, equality, and dignity given in the Constitution or given in the international covenants, that is the UDHR, the ICCPR, and the ICESCR, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Socio, and Cultural Rights. All of the rights that are mentioned herein, that are with respect to life, liberty, equality, and dignity, and given in the fundamental rights chapter, and the only criteria is they should be enforceable by the courts in India. Now, there were certain, when we signed the UDHR, we said that 1 or 2 articles from the UDHR would not be applicable to India. So there is a question of whether those rights are the ones that are not enforceable by the courts in India, because if they are not enforceable, then they do not belong, though they are in this document, they do not belong to this genre of human rights. Now, but if you look at the case laws, I mean, Andhani Sakpiti and all of those bunch of cases, we have given compensation for unlawful arrests as well. And therefore, there is a rider to that. Though we said that these are not applicable, the Supreme Court has actually given those rights through these various cases. And therefore, maybe all of those rights, by that interpretation, could be a part and parcel of our human rights. Now, is there anything that is beyond these documents that can be claimed as a human right? That is the next question. Is there an answer that anybody would like to give? You can unmute yourself and speak, I suppose. Are there any rights that are not given in these documents? That's the fundamental right, or the UDHR, the ICCPR, or the ICSCR. If they are not mentioned in those documents, can they still be claimed to be human rights? Can we still claim human rights with respect to those? Any answers on that?
Yes, ma'am. We
Yes.
can still claim human rights because human rights are born from our birth. So we can claim whether it not given any book.
Whether it's mentioned or not. Thank you so much, because what you are stating is that since the claim is for the fact that we are born as human beings, and it's not on account of these documents of fundamental rights or UDHR, ICCPR, or ICESCR. It's not because of them that we have human rights. We have these rights by virtue of the fact that we are born as human beings. Thank you so much. Have I summarized correctly what you said? we do have a right to education, we do have right to live with dignity. Right to live with dignity is under Article 21, and right to education has come in under Article 21A right now. And they were there in the other document, that's the UDHR. Now, I'll therefore bring your attention to the Section 2 of Protection of Human Rights Act. Unless the context otherwise requires, then we go down to the section and we say that human rights would mean what I told you just now, such and such things. Okay. Now, I would like to bring your attention to, unless the context otherwise requires, human rights would mean these. Means, I take the corollary of it. If the context requires, human rights may mean something else that was not with respect to life, liberty, equality, dignity, or given in UDHR and all of that. Right? So in the very definition of the human rights given under the Protection of Human Rights Act, we have a claim over there that if the context requires, I could claim something beyond what is there given as a list of rights, as a list of human rights. I move on to the next question to all of you. Is torture ever justified? And that's the first part of my lecture today. Is torture ever justified? Put yes or no in the chat box. Never, never, no, yeah. Yeah. All of them say no to it. In no case can torture be justified, right? And particularly on the day when we are speaking about human rights. But there is a very foundational question associated with this particular thing. I will take you to another country, that's Germany. Each one of us have heard of Hitler, Nazi Germany. That some questions, some answers that are coming in maybe in certain cases, and let's see whether we can raise a debate with respect to that. And the focus is whether a torture is at certain points justified for a bigger reason, and what could be that reason, if at all, if it is to be justified. And that's the debate what we are going to look into. And first, before we go further, I'd like to draw your attention to Germany. And I take Germany, you'll get the reason why I'm going towards that. Germany has had a history of that is hugely burdensome. Not that other countries have been absolutely peaceful, but we have been reading about Hitler. We have been reading about how Hitler thought the Nazi race, the Aryan race, as he called them, their race to be. They were the superior race, and that all other race weren't good enough. And if we wanted a future world of intellectual beings, of good quality humans, then we should not have those races that are not of that great quality to proceed at all in the future and be a part of the future. And millions of Jews, and not just the Jews, there were many more other races, people who were there, who were put to gas chambers, who were killed. So it was a genocide. And the justification that Hitler gave was that Aryan race is the best race in the world, and that that is the only race. If you want to have a quality life in the future and have a common good, then he justified it by saying that. And Germany is the land of Kant. I suppose most of you would have read Immanuel Kant and his treatise on treason and a lot of other subjects. He is the founder. He's known to be the father of human rights. And if you look at the German constitution, it talks about, see, I have put the article over here. Human dignity shall be inviolable. To respect and protect it shall be the duty of all state authority. That's German Constitution, Article 1. Of course, Immanuel Kant was from the period of 1800s. He spoke about categorical imperatives. He said that why a certain thing should be right, and he stressed on the importance of humans being treated with dignity and respect. Human beings should never be treated as a means towards something. I want to achieve something, so I use one person as a means to reach my goals. That should never be. We end up disrespecting that person. We end up disrespecting the humanity in him. He was a proponent of that idea, and he is famously known, therefore, as the father of human rights. A lot has been written by him on that, and particularly see from the place that from Germany that he is, in that very place around before 1945. This is what was happening, Hitler and Nazi Germany and all of that. Eventually, Germany comes up with with the first article in the Constitution saying that human dignity is inviolable. For whatever reason, you cannot interfere with the dignity of any person. Now, it is in Germany itself that I'll be telling you this particular case. Jakob von Metzler. This child, 11-year-old, son of a banker, he was kidnapped by this person, that's Magnus Gafkin, who was a student around 27 years of age. He kidnapped the boy and he asked for a ransom. And he was arrested. And when he collected the ransom amount from the parent, immediately thereafter, he was arrested by the German police. And in custody, this is the other person who is the deputy police chief. The deputy police chief inquired a lot about where is the child, because he wasn't releasing the child even after he had received the ransom, and he was not at all willing to tell, and all questions had only failed answers, right? And eventually the deputy police chief, Dashner, he took matters in his hand, and he said that if you do not tell us where the child is, we will use force on you in such a manner that you have never ever experienced in your life. He threatened him with torture, and being afraid, he broke down, Magnus, and he said that this is where the child is, and he had by that time killed the child, and the child is no more. And then they recovered the dead body of the child. Magnus was sentenced to imprisonment, convicted and sentenced to imprisonment. But approximately 2 years later, we find that Frankfurt Deputy Police Chief Wolfgang Dashner was prosecuted for threatening to use torture. Now, this matter that was pending in the court brought in a huge debate amongst the members of in the German society, that many of them favored the deputy police and said that what else could he have done? It would have been better that, if at all threatening could bring out the truth, and it could end up saving the life of the child, then therefore many of the German people, the society was equally divided. And this question arose whether, threatening to use torture or torturing could ever be justified, where it would lead to saving the life of another person. What would you say to that? Let me have a few answers to this.
No, ma'am. I
Yes.
think it was wrong. It was wrong because
Okay.
there is another human life is also there, and the Frankfurt deputy police chief was trying to save that life. So to save the life, uh, they can
Of the
use
child,
torturing methods. Yes, yes.
you would agree to torture because it is for the saving of another life.
Yes, ma'am.
Okay. Would somebody like to answer to what Omkar has stated? Does anybody has a counter reply to that? Or let me just have your answers in the chat box. How many of you would be agreeable to the use of torture when the result of that would be to save the life of another? How many of you would be agreeable to it? Say yes in the chat box. Or say no, not agreeable. Partly yes, okay. Partially agreed, but not third-degree torture, okay. As in this case, that we see that, this person did not really end up torturing the person. He threatened and he said that if you do not tell, we will, force you to, and things that you have not imagined. And with that itself, and you know what, in like, I'm getting so many answers. Thank you so much for that. And if you could also give some reason as to why you would say yes or say no to it. Okay, so they're still not agree over torture. Now, if we analyze these arguments, okay, and we are going to move to analyzing these arguments, why would you be agreeable to, okay, torture justified in such cases, and why would you not be agreeable to? In which kind of cases would you agree, and in which kind of cases you would not agree? Can I have some answers on that? In order to serve duty, he have to use force to save the child. Okay. In order to serve his duty, torture to save another is not justifiable. Very nice. Partially agreed, but not third-degree torture. Okay. Then wars are not to be considered. Okay. Great. A lot of answers now. Could you make more? Could you make sometimes to save national interest? Okay, fine. So if you say, if I know that that this person has planted a bomb in filled an auditorium, and I want to know from this person, where is it, to save all the people in the crowded auditorium, would I be justified in employing torture?
Yes, ma'am. At that time, we must use torture method because there are several peoples who were there, and to save their human life, because they are also human.
Okay, great. So, if you were the judge of this particular case, the previous slide, what we said just now, this person has been brought in for, is being prosecuted for threatening to use torture. How would you judge this matter? Those of you who have said that maybe torture is justified in certain occasions where it is to save the life of a child, maybe you would say that, this person should be acquitted because eventually he was doing what he did was he wanted to save the child. Of course, he has violated the law because the Article 1 of the Constitution itself states that you cannot employ, that human dignity is the prime thing over there, and he is violating that provision. So though he may be violating the law at that point of time, you would say that he would be justified, I mean, because there is a life of a child involved, and if the child could be saved, you are not killing that other person by torturing, you're saving the child from the other person. Let me hear some responses as to why it will not be okay to do this. let me hear some response as to why it would not be okay to do this. Who has a right to torture anyone for the sake of any reason? Okay, so for whatever be the reason, I do not have that. I cannot claim that kind of a right that I can torture one person for the sake of helping another person, right? Or I do not have that kind of a power to. Yes, is there somebody who would like to say something?
Can I say something?
Yes, sir.
Yes. Ma'am, if it is allowed in one case, it will lead to misuse of the power by others. That's what I feel. Because it will lead to
Okay. And that will create a society which favors torture. And in the end, we will have a bad society. That's it?
Yeah,
Is that the reason?
that's yeah.
Is that the reason?
Human rights cannot be violated to save the other human rights.
Okay. But then see, I mean, if I put person in a difficulty, okay, because the question over here, if you see, if I'm asking this, did he violate the kidnapper's rights? Omkar here would say that the kidnapper himself wasn't doing a very dignified act altogether, right? He himself was also violating the other person's rights. What about respect for human dignity? But then you'll say that then what happens to the dignity of the kidnapped child? Wouldn't we want to save his dignity as well and his life as well, right? So that we sort of get stuck into those kind of problems about not doing so. If I don't torture him, I know that if I torture him or if I put him into some kind of a threat, he would I mean it will end up saving the life of another person. And if I don't
Madam,
do
1 minute.
that,
Madam,
know
1
for
minute.
sure that the other person.
Madam, 1
Yes,
minute.
sir.
All the participants, after asking your question, mute your mic. It's causing inconvenience for others to hear. After your talk, mute your mic. Bhupati, there are several people who are unmuting their mic, causing inconvenience for others to hear properly. Go ahead.
Yes, sir. So not only not doing so would make me responsible for the death of that child, right? So Kantians is sort of the I mean those who are from the Kantian philosophy, that is, in no case torture is justified, somehow fail to acknowledge that if this is done, I would end up saving the lives of the others, and that's the absurdity in the whole of it, right? What if there are many lives involved, right? I know that somebody has planted a bomb, and if I can threaten him to some extent, he'll be telling it, and I'll be able to save that. Now, this argument which we are giving just now, or which I'm giving here right now, is a utilitarian argument that it will be useful in the long run. It will be useful for having a more ordered society, a more peaceful society, or a society wherein there would not be, say a bomb blast is being planned, and it's likely that around 1 lakh people will die over there. If I can threaten this person into telling me where the bomb is, I can save the lives of so many. Now, these two arguments that I'm speaking about, one, that if I threaten this person or torture this person, I'll save so many, I'm making a utilitarian argument. It'll be useful, it'll be for the common good, it'll be more for maximizing happiness. Utilitarians would tell that if individual right is put at stake for the sake of the community good, and if the community's good is ensured, it does not much matter if one individual's rights are at stake over there. Whereas a Kantian would say that you cannot use him as a means to get to an end, and the end is that I don't want to know where is the bomb that you have planted. Right. So using a person is disrespecting that person. And that's what people, utilitarians would say, that Kantians refuse to acknowledge that, that it is necessary in certain cases, or it's so absurd that to protect the right of the murderer, or to protect the right of the, the person who has planned to put in a bomb and to kill, to protect that person, we are, putting at stake the lives of 1 million other the rest of the population over here. And that's the whole debate about it. What if there are many lives involved? What would we do? Torture may be justified if it is serving the common good, is what I was telling you just now. If I can save the child and I don't, wouldn't I be responsible for the death of the child? I could have saved the child by threatening this person, and now if you do not allow me to do it, I'm sort of tied up, right? This is the argument that the utilitarian would make. And the Kantian people would make or say that, certain rights like life, dignity, liberty are so inviolable that you cannot interfere with them at any cost, even if it is for the saving of the life, even if he is a murderer, even if you know that he is a hardened criminal, you cannot interfere with the right of that person. His rights are his. He will say that my rights are mine, and I'm not there for public use. If you can trample upon me for the saving of the society, yeah, please, I'm not there for that reason. You cannot use a person as a means. And so I have brought to you the argument that, the two arguments that are there as to whether torture would be justified in certain cases, or, it should not in any case be justified. I do not know whether you know of this person, D.K. Basu, a former High Court judge. D.K. Basu was the state of West Bengal, wherein the Supreme Court eventually laid down guidelines to ensure that, to reduce torture matters in the Indian prisons. Every state was asked to give data about custodial deaths. That's in India. We know how, very frequently that there are so many, and most recently, we keep on hearing those kind of examples. Do the police can claim, from what aspect can they claim a power over the person who has been arrested, that to be able to torture that person? It is our criminal justice system would say that his rights need to be protected, and we are going to look into some of these. But before that, I want to draw your attention to the Police Act. That's Section 29, penalties for neglect of duty. Every police officer who shall offer any unwarrantable personal violence to any person in his custody shall be liable. So this is a hugely old act, some 1861 or something, which actually says that the police can be prosecuted and punished if at all there is proof that they have employed, or I mean, if they are prosecuted on that basis that they have violated the rights of any of the person who's been arrested. Closing that first topic, I know I'm already late. I'll move you to another important right at hand, and that to right to privacy. And before I launch on to about the debate about privacy and the common good, I would like to tell you that privacy has not yet been defined and laid down under any of the articles of the Constitution. So we do not seem to have a right to privacy entrenched in it. Yes, but as we know that there are a bunch of cases that has given us and has said that we do have a right to privacy. But if you look at the epistemology of privacy article that the court has referred to, you'll find that there is a huge lot of confusion about privacy in the physical world, privacy in the online world, and in many other matters, that it's such a big subject. Every part of it can't be discussed. But today I'm going to try and take one aspect of it, as to if there is a case wherein my laptop or my phone has been seized by the police and it is under a password, can I be compelled to give the password? Okay. When in this background, we are going to look at Article 20 and Article 21 of the Constitution. 23, clause 3 says, no person accused of any offense shall be compelled to be a witness against himself. Okay, I cannot be compelled to give testimony against my own self. That's one thing. And second, no person shall be deprived of his life or personal liberty except by a procedure established by law. And we know that the procedure established by law must be a due process. And we also know that this life and personal liberty has been expanded in such a manner so as to include right to privacy. I draw your attention to section 161, clause 2. Person shall be bound to answer truly. Any person who's been arrested and is being interrogated by the police, he is bound to answer truly all questions relating to such case put to him by such officer, other than the questions, the answers to which would have a tendency to expose him to a criminal charge or to a penalty or forfeiture. Right, goes well with Article 20, Clause 3 of the Constitution, that he cannot be forced to depose against himself, right? Other than the question or answers to which he should help the police in the investigation, but he need not answer questions that are directed against him, provided the statement made under this section may also be recorded by audio, video, electronic means. That's important because that's possible today, and whether there we can have some support in our arguments later. Okay, so the question is, would providing a password or a passcode or biometric amount to self-incrimination or testimonial compulsion? Come on, quickly answer in the chat box. If I am accused of some offense and the police have conducted a search and seizure of my house, and they have taken away my laptop and my phone, and I have a passcode for it. Okay, the police is compelling me to give the password, and I feel that if I give the password, they will have documents in my password which will be self-incriminating. Giving of a password or a passcode, is it testimony against myself? Will it amount to self-incrimination or testimonial compulsion? Okay, so some of you have said no, and yes, and the Evidence Act, yes, of course. I could not bring everything under this today over here. I'll bring your attention to this Virendra Khanna versus State of Karnataka. This Virendra Khanna is a person, he's an engineer in information sciences, and he had gotten into a job which he left in favor of setting up his own venture, and that's about event management. And it so happened that in the events that he had managed, there was supply of drugs and all. And his claim was that he looks only partially into the event management and not with respect to every aspect of the event management. So if related case, then no. Okay. And then he had gone to Delhi. He is from Bangalore. He went to Delhi, and he was staying with his parents when the police came, and they had arrested him, and they had confiscated his laptop and his phone. And this was during the COVID time that he was also called to the Bangalore police station, and he was brought in over here. He was told that you have to give the password for the laptop and the phone, and he claimed that he has a right against self-incrimination. He has a right to privacy. There are many things in his laptop and in the phone that he would not like the police or any third party to see. And he claimed privacy with respect to the passcode, and he should not be compelled to give the passcode. Now, whether right to privacy, I mean, by this time we already had Kutaswamy. So whether the right to privacy would ensure that, or whether he should help with the investigation. If he is not, then and the question and the thing is, all the documents that are found in his laptop or in the phone, they would just be maybe corroborating evidences. Okay, the question is it a testimonial evidence against himself? And to that, the court in Karnataka, the High Court of Karnataka stated that there is no testimony which is given by the accused by providing the password or the passcode or biometrics. The question also arose whether he should be put through some polygraph test, some polygraph test, wherein he will be asked the password for the laptop or the phone, and whether that would be self-incriminating. And we do have the Selvi's case prior, that a person can only be put through a polygraph test or any of those BAP and all the five kinds of tests that we have. We can only subject somebody through such a test only with his consent, not without his consent. Okay, so he said that he's not consenting to it and he did not want to give. But the court insisted that and said that you are not giving a testimony against yourself. You're just, in this case, you're contributing to the inquiry and the investigation of the matter. Password is not a testimony against you. The presence of a document in the laptop or the phone per se does not establish the guilt of the person. It needs to be established by the prosecution. And very interestingly, around the same time, CBI versus Mukesh Kumar Sharma. And by this time, when this matter is being decided by the Delhi High Court over here, Virendra's matter, Karnataka High Court had already stated that he needs to give out. So the Delhi High Court first said that we are not bound by what Karnataka High Court is giving, and then said that when an accused is asked to disclose his password, it is in his mind, he's going to give. So to apply his mental faculty or a memory to give the password, it is purely on a mental effort. So it's about a testimony, and therefore it's a testimonial fact. And he cannot be compelled to give any testimony against himself. And there was this discussion that, password cannot be considered in isolation. When somebody gives his password is in his mind, right? So we are looking at a testimonial kind of something, wherein if he gives that testimony, then there is this laptop which will open up, or the phone that will open up, and there will be many documents that goes against it. And it will then be considered to be violation of, it will be a violation of Article 20, Clause 3, right, as well as the privacy right. Now, these are two conflicting cases that bring to us the question about biometrics and passwords. Some time back, we were bothered about whether, if the state has a record of all people's biometrics and, about all our fingerprints, eye prints, and all of that, is that a violation of right to privacy? Or when we talk about Article 23, when we say he shouldn't be compelled to be a witness against himself. To be witness means what? Means imparting knowledge in respect to facts and making statements, right? Which comes out of my personal knowledge. When I talk about password, it comes out of my personal knowledge of the facts to be communicated to the court or to the person holding an inquiry or investigation. So would you then say that it's a testimony? So the question that is the bigger question underlying the two matters that I brought to you is the difference between physical evidence and testimonial evidence. If you look at CRPC gives a lot of power to the police to inquire into to investigate any matters, and for that they can take a warrant, general warrant or a special warrant. Even general warrants are possible. They can enter my house, they can search my house, and they can take whatever evidences that they think will be relevant and in the matter for the investigation. Now, if you see that, is this power too big a power that has been given to the police? And is it that it's violative of individual dignity, human rights, and all of that? Now, the bigger question then that comes in is my privacy right or my right against self-incrimination vis-a-vis an ultimate goal that is of a peaceful and an ordered society. If by troubling me a little bit, if I quote, and CRPC and Evidence Act and all of that is towards getting to the root of who is the person who has done done the particular, criminal act, and eventually giving a punishment for that, right? But then the way in which things are done, as if you look at Germany, US, India, they're different. But then in most cases, commonly throughout, we find that there are a lot of, acquittals that keep happening. Number of crimes are increasing, but number of acquittals are also very high. Somehow a balance needs to be struck. And at the core is an individual as against the societal common good. What is for the common good? We all need an ordered society. We all need a lawful society, a place where we are all safe. And that's what the state and the police have to ensure. And in ensuring that, sometimes an individual right comes at stake. And that's the bigger question that's at the root of it. I would like your inputs on that. I have brought to you the two major things wherein there is a friction between the individual right and the community common good. And a discussion on that is what I suppose would be required as to the foundational questions of criminal justice system. Would we be in favor of the common good more, and at the stake would be some individual right? Or would you think that individual rights are so inviolable, like the Kantian theory, that at any case, even for the common good, it cannot be put at stake? And I hope you'll ponder upon that through the day. I'll like some responses on these. Thank you.
Thank you so much, ma'am. Am I audible to you all?
Yes, yes, yes.
Thank you so much, ma'am, for enlightening us with your informative and interactive session. Thank you once again from all the participants. Now we will proceed towards the answer and queries session. So if there is any queries from the participants, can kindly put it into the message box.
Already chat box में questions है. Go ahead.
Yes, sir.
I see over here, yes, some responses are there. Article 20, self-incrimination. So yes, so we are fully, yes, fully allowed not to share the password. Okay, but as you see here, there are two conflicting decisions now, and eventually the question is about individual versus common good. Passwords, if you look at it, that it's a physical thing, right? The laptop and the phone is a physical thing, and the police, with a warrant, has the right to search my place and to seize certain articles that they feel would be relevant in the investigation. And if they have a right to take my phone or my laptop, then they also have a right to look into that, right? That is the reason why they're taking my phone or my laptop, right? And if they have that power, then I have to give them the password. That's one way of looking at it. And it'll be helping with the, or else I would be interfering with the criminal justice system. And on the other hand, if you look at it from how Delhi High Court looks at it, that when you are, Delhi High Court is very formally looking at it, that if you are, if the password is coming from your mind, then it's a testimony. But if you looked at 23, it is about self-incriminating sentences, right? Where I tell that, yes, I'm the person who's done it. Now, even Selvi's case that said that, I may be put through a polygraph test with my consent. The point is, whatever I say over there will not be taken against me in the court as it is, right? It may be, I would have given out a lot of factual details also, but those need to be corroborated by the police. It's not that directly on my speech in a polygraph test, I would be convicted of the crime, right? So Act 93 provides human rights code for speedy disposal of cases violation like present one or the state government are yet not established. and they are appointed already working session to trial when judges already heavily burdened. My question is how the object of providing speedy disposal of such human rights violation cases made working and objectives achieved. Yeah, that's about as I think Sadhna Jadhav ma'am had answered this, that about speedy disposal of cases, because she said if it is very much hurried, it is also lost. Justice is lost in that cases. So we need to carefully think about it. But my session or my point was more about not how these cases are to be handled, a more fundamental question of how our laws should be designed. Should it be designed in the German model of where individual rights are so inviolable that there should be absolutely zero cases of torture coming in through prisons, or zero cases of violation of individual rights? But then at stake is the question of the common good, and how we are, and that's the more fundamental question as to how we are going to organize our criminal justice system. Okay.
Next question is from
Any more
Reena
questions?
Pillai, ma'am. I would like to know your opinion on the question.
No, you would like to know your opinion on the question. See, I have raised a philosophical debate, and these aren't to be answered in a manner that, how I think a certain thing would be right, wouldn't make it right for the rest of the society. Okay, if you look at it, if you look at the US laws, Locke has a huge influence. I mean, libertarian rights, individual rights, not the Kantian sense. Kant also talks about individual rights. I mean, Kant is Germany. Germany has a huge influence of Kant in their laws, whereas US has a huge influence of libertarian rights in their laws. But it's not an individual rights because I'm the owner of myself, kind of. Okay, Kant does not say that because I'm the owner of myself. Kant says that because I'm a human being, I'm entitled to a dignified behavior, right? But then libertarians differ there. Now, the thing is, all of US laws, which are very much individual centric, and if you look at the present day lectures of the American philosophers on justice and on rights, they are more moving towards the value of common good. Now, if you look at Indian laws, we are more towards common good, and all our arguments are moving towards individual rights, which US has already gone through individual rights and are moving and are wanting to move. But yeah, it'll take another 100 years for them to move towards the common good kind of arguments. But we already have, if you look at Indian laws, we have the common good thing more in it. I mean, if you see CRPC evidence and all of that, you'll find that it is necessary that, for the sake of the law and order society, and that's the duty of the state. That's the duty of through the police mechanism that the state does, which is necessary, which we all will agree it's necessary. But at the same point of time, we do have Article 20, Clause 3, which is in a very restricted place talking about right against, don't compel me to speak against myself, which is equally true, but not saying that, all of individual rights are inviolable, human dignity and all of that. It's there partially in the preamble. But when you start working it out, preamble may be the goals. When you start working it out, you need clauses in the sections, in the articles of the Constitution and the statutes. So we do have the Police Act, which says that you cannot violate people's right. We also have Article 20, Clause 3, that, you cannot compel a person to give, incriminating evidences against himself. Now, then by that logic, the same thing, goes ahead and says that my laptop and my phone, whatever is there inside it, there might be incriminating material, but I am not giving testimony against myself in that case. That's how see, the whole thing is how we design our laws. And how we design our laws is how the whole of India feels. Laws are to be passed by majority, after all.
Next question is from Omkar Raut. When person is already convicted and sentenced, can police torture him to obtain information regarding other crime?
Police can, in no case, torture anyone prior to or after. The law, as I told you, in the Police Act, it says that if they ever do that, they can be prosecuted and punished for that. Now, maybe you're looking for whether it would be justified to do it. I was talking from the jurisprudential, the foundational aspect of why the laws are the way they are, right? The kind of torture that we hear of in Indian jails and all, certainly not agreeable, right? It's just that police are somehow making their job simple by saying that, you torture the person, you get the details out of him, and you just, it makes their job easy. And their complaint has always been, I mean, we had a commissioner of police who would be coming to our college to teach. So he would always say that, we are so, manpower is so less, and the number of criminal activities are so big, it becomes very difficult to, properly do everything. And that does not justify torture, of course, right? But then police find that as a shorter method, or, a shortcut way of, completing their and closing the file. And after having done so much as well, there are so many deaths resulting. We don't see any kind of, the convictions going up. We are equally bad in that. A lot needs to be done with respect to our criminal justice system.
Okay, thank you so much, ma'am, for answering all the participants' question and for enlightening us for all the informative and for engaging an interactive session. Now I request to Pradyumna Shastri sir to propose the vote of thanks.
Thank you very much, Uma ma'am. Good morning, everyone. On behalf of MP Law College, I am Pradyumna Shastri. I extend really hard votes of thanks to our resource persons for today's Dr. Shampa Dev ma'am, belongs with the Christ Deemed University, Bangalore. Ma'am, you are explaining us regarding with the different laws, articles, rights of persons regarding the practical case studies. Really, these things are helpful for us, and really thankful you find your busiest schedule time for this occasion. And today we'll learn many regarding things about this. Really, these things will encourage us regarding practical case studies and regarding our future events. Thank you very much, ma'am. I'm also thankful regarding presidential management, Dr. Rao sir, principal of our college, Morris sir, vice principal of our college, Raparna Kutapalle ma'am, AQCA, all the senior staff member, colleagues, and definitely because of the anchors, Uma ma'am, Uma Shinde ma'am. Thank you very much for all of you. Thanks for giving me an opportunity. Vote of thanks. Thank you, everyone.
Thank you so much. Thank you for having me.
Thank you, sir. Thank you, ma'am. Now we conclude the second session, and I request Mr. Sukumar sir to take over the third session.
Madam, Rajendra Saab aa gaya?
Yes, sir. He is online.
Okay.
Yes, I'm here.
Thank you so much, Uma ma'am. Now we move on to the third session, third session of the event. The theme of the session is criminal justice system, the role of advocates in protecting human rights. It is my honor and great privilege indeed to introduce to you Dr. Advocate Rajendra Anbule sir. Sir has done MA in political science. Sir is a gold medalist in LLM. He has completed his PhD in law, and he is a Supreme Court advocate on record. In the year 2000, he has been the recipient of B.N. Shrotri's Best Student Award of ILS Law College, Pune. He stood first in the Pune University LLM examination. He completed his PhD on the topic of gender justice and law under the Constitution. He was the in-charge principal of Marathwada Mitra Mandal Shankarrao Chavan Law College, Pune in 2004 to 2006. Sir worked as a visiting faculty for LLM in Bharati Vidyapeeth New Law College, Pune since 2007. He practiced in Bombay High Court, Supreme Court of India in the area of, namely, constitutional law, civil laws, criminal laws, personal laws, service and education laws. He has been a member of Board of Studies in Faculty of Law at BVP Pune. He worked as the member of an academic council of MNLU Mumbai. He also worked as the honorary director, Center of Advanced Legal Studies Training and Research of member of Academic Council of MNLU Mumbai. He also worked as the chief coordinator of Bar Council of Maharashtra and Goa. Sir is notably renowned for his PIL, which ultimately resulted in the 1% reservation given to the orphans in the state of Maharashtra. Further, Sir filed the PIL, as a result of which full-time protection officers were appointed in Maharashtra under the Protection of Women from Domestic Violence Act. And Sir has acted as resource persons on various platforms such as Bar Council of Maharashtra and Goa, Maharashtra State Commission for Women, Women and Child Development Department Maharashtra, and Yashwantrao Chavan Development Academy Pune, Police Research Center Pune, Police Training School Kandala, and State Intelligence Bureau Pune. With that introduction, I would like to invite Sir to kindly deliver his address. Over to you, sir.
Thank you very much for kind introduction. Am I audible?
Yes, sir.
Yes, sir.
I am thankful to the organizers for giving me an opportunity to address on the topic of role of advocates in protecting human rights. It is said that advocate is not only a person who is practicing law in the court, but he is even officer of the court. And as far as implementation of laws are concerned, he is connected to that particular process. As a part of law implementing mechanism, advocate is always involved along with judiciary. Very importantly, so far as Indian criminal justice system is concerned, we can say that right from the commencement of the constitution till today, advocates have played very important role in evolving even human rights jurisprudence in India. As we are discussing the topic of role of advocates in protecting human rights in India, at the very outset, it is essential to discuss what the concept of right is. Concept of right has been developed parallel to natural law theory. As we know that right from ancient era till today, natural law theory has underwent various changes. But two principles of this theory have never been changed. The first was universal order governing all men, and second principle of natural law theory was inalienable rights of an individual. As far as first aspect is concerned, universal order governing all men, that particular aspect has been covered by Article 14 of the Constitution of India, wherein Article 14 says that states shall not deny equality before law and equal protection of law within the territory of India. In 1975, when Indira Nehru Gandhi versus Raj Narayan was decided, Apex Court has held that equal justice is basic structure of the Constitution, which cannot be amended under Article 368 of it. Today, the law is settled to the extent that even if Parliament want to amend the Constitution, Article 14 cannot be amended, or the aspect of equal justice cannot be amended. Second part is there in relation to rights, that is, rights are inalienable rights of an individual. So fundamental rights which are available to everybody cannot be waived by that person. In Basheshwar Nath versus Income Tax Commissioner, Apex Court has clarified that fundamental rights are there in the Constitution as a matter of policy, and they are not subject to waiver. Now, very importantly, as I said earlier, that the concept of right has developed parallel to natural law theory, and these two principles, that universal order governing all men, and secondly, inalienable rights of an individual, have never been changed. These particular aspects or principles are incorporated even in the Constitution of India, as I said earlier, in relation to Article 14 and in relation to even Article 13, wherein Apex Court has evolved doctrine of waiver. Now, so far as concept of human right is concerned, this concept of human right has been evolved in India or in even in the entire world, even after 1945, when United Nations was established. In 1948, Universal Declaration of Human Rights was declared by United Nations, and after that, so many conventions were promulgated, wherein one of the important is of 1966, which is known as Covenant on Civil and Political Rights. As India is also state party to that particular covenants and even to the United Nations, it is the duty of India as a member state to implement the mandates of all conventions and declarations which are pertaining to human rights. Now, as I said earlier, that Constitution of India is there, which provides implementation of concept of human rights or natural rights, which has been developed parallel to natural law theory. Article 12 to Article 35, which discusses about chapter on fundamental rights, deals with even the issue of human rights. But all fundamental rights are human rights. If you see some judgments of Honorable Apex Court, like Golaknath versus State of Punjab of 1967, or even Keshavananda Bharti versus State of Kerala of 1973, Apex Court has tried to discuss even the concept of right, which has been evolved along with natural law theory. But Supreme Court had not given the name human right so far as these fundamental rights are concerned. Rather, could discuss these rights as a part of natural rights. But it may be a fundamental right, it may be a human right, or it may be even a natural right. The meaning is same as far as protection is concerned. So, as I said earlier, if Constitution is there, then human rights are regarded as fundamental rights. But very importantly, all human rights cannot be treated as fundamental rights. Only those human rights which are incorporated in the constitution of any country can be treated as fundamental rights, because constitution is fundamental law of that land. So a right recognized by constitution is treated as fundamental right. That is the basic difference between fundamental right and human right as far as recognition is concerned. In India, as I said earlier, all human rights are not enforceable under Article 32 of the Constitution or even under Article 226 of the Constitution, but all fundamental rights are enforceable. Very importantly, as we are discussing about role of advocate in protecting human rights, the very important forum which is available to them is Article 32 and Article 226, wherein Supreme Court can exercise jurisdiction under Article 32 Clause 2, and High Courts can exercise jurisdiction under Article 226 Clause 2. But the basic difference between these two articles is that so far as Article 32 is concerned, aggrieved person can approach to apex court only for the enforcement of fundamental rights, but under Article 226, any other right, even including a statutory right or customary right, can also be enforced under Article 226 by filing a writ petition in High Court. Now, as I said earlier, that there are so many even judgments are Supreme Court of India, wherein court has clarified that it is not only a police machinery or even a judge who is sitting in the court, that they are part of justice delivery system. At the same time, even advocates are also officers of the court, and like judges, they have also very important role to play in administration of justice. That's why when we are discussing about implementation of laws and interpretation of laws which are made by the parliament, advocates plays very important role in that, because they are closely connected to law than any other section of the society. And so far as effective protection of human rights are concerned, they can play a very important role. Another important aspect is there in relation to advocates, that is, they are not connected only to law, but as an intellectual member of the society, they are even connected to society also. And they know the connection between society and law. So they can do social legal practice. They can redress some social issues which are there in the society. And in regard to that, role of advocate is very material, or that is very central one. Now, as far as today's topic is concerned, which has been given to me, that in criminal justice system, what role advocates are playing or discharging in protecting human rights. As far as India is concerned, today I am going to discuss 3 to 4 important aspects wherein advocates are playing key role as far as protection of human rights are concerned. About right to equality. Article 19, 20, 21, 22 discusses about right to freedom. Article 23 and 24 discusses about right against exploitation. Article 25 to 28 discusses about right to freedom of religion. Right? Article 29 and 30 discusses about cultural and educational rights. And Article 32 discusses about right to constitutional remedy. These 6 fundamental rights are there, which are protected and guaranteed by Part 3 of the Constitution. Now, very importantly, as an officer of the court, when advocates are doing litigation practice in the court of law, not only in the area of criminal justice, but even in other area also, they can effectively work for protection of human rights. Now, the concept of human right is not related only to criminal justice system. It is related to even other aspects also, like even in Subhash Kumar versus State of Bihar, Supreme Court of India has clarified that right to potable water and right to fresh environment is a fundamental right under Article 21 of the Constitution. But as far as today's discussion is concerned, our area of discussion is criminal justice system and role of advocates in protecting human rights. So in relation to that,
Your voice breaking.
There's a network issue, sir will be rejoining. Sir, you may proceed. Sir, you may proceed.
am I audible?
Yes, sir.
There was some network issue. I'm extremely sorry. So the topic is in relation to role of advocates in protection of human rights. I'm going to discuss 4 to 5 important aspects wherein advocates are playing very active role in India in protection of human rights. The first important aspect is there, and I may say that that is one of the mode by which advocates can effectively discharge their role as a protector of human rights. In 1950, when Gopalan versus State of Madras was decided by Apex Court, court interpreted Article 21 in a restrictive sense by saying that Article 21, 14, 19 are not related to each other and they don't form part of one single scheme. At that time, Supreme Court of India was highly influenced by analytical legal positivism of Austin that law is a command of sovereign. And there are several judgments of Apex Court wherein court has clarified that we are here only as a servant of the legislature and we cannot make something new. But in 1978, when Menaka Gandhi was decided by Supreme Court of India, Gopalan versus State of Madras was overruled. And after 1978, criminal justice system was developed by Apex Court in leaps and bounds. In Menaka Gandhi, in 1978, Apex Court has developed doctrine of inclusivity of fundamental rights. That Article 21, Article 19, and Article 14 are closely related to each other, and they form part of one single scheme. In development of this particular Article 21, as today so many rights have found shelter and protection under the canopy of Article 21, advocates have played a very important role in shaping and molding and even developing Article 21 and other articles, including Article 14. Now, very importantly, you all must be aware that after 1980, Apex Court has taken a different view while interpreting Part 3rd of the Constitution in the wake of Menaka Gandhi case. And after disposing SP Gupta versus Union of India and even ABSK Sangh versus Union of India, Apex Court of India has invented a new instrument for the enforcement of fundamental rights, that is social interest litigation. This name was given by Apex Court in 80s to PIL, but today PIL are known as public interest litigation, or social interest litigation are known as public interest litigations. Under Article 32, Clause 1 of the Constitution of India, any person who is aggrieved can approach to Supreme Court by appropriate proceedings for the enforcement of fundamental rights guaranteed by Part 3rd of the Constitution. Till 1980, the Supreme Court of India was of the view that only that person whose right has been infringed can invoke the proceedings of Supreme Court by filing appropriate proceeding under Article 32, Clause 2. But when SP Gupta was decided, when ABSK Sangh was decided, when MC Mehta versus Union of India was decided in 1987, Apex Court of India has given different meaning to Article 32, Clause 1 of the Constitution. And court has clarified that even though a person's fundamental rights are not violated, that person who is a public spirited citizen can approach to us. He can file petition on behalf of another person who is not able to approach the court due to poverty or due to any other reason, that he may be a weaker section of the society, he may be an illiterate person, he is not aware about his rights. Any public spirited citizen can come forward, he can file public interest litigation in Supreme Court of India, and he can enforce fundamental rights of another. Due to this particular positive approach which the Supreme Court of India has developed under Article 32, Clause 1 of the Constitution, and due to this new mechanism which the Apex Court has provided for enforcement of enforcement of human rights or even protection of human rights, advocates have a very important role to play so far as PIL jurisdiction is concerned. As a public spirited citizen, they can file PIL on behalf of those who are poor, who are not able to approach the court, and they can protect the human rights of those persons who are vulnerable. There are several examples wherein advocates have played very important role in protecting fundamental rights or even human rights of common persons. Uh, you must be aware about the judgment of Apex Court of 1987 when MC Mehta was decided by Apex Court of India. In MC Mehta, even court has clarified that even a letter written to a Supreme Court judge can be treated as a PIL or writ petition. And after filing of that particular petition, if court came to know that there is violation of fundamental rights, then even court can issue social legal commissions with a view to redress that particular issue of violation of human rights. And in appropriate cases, even Apex Court clarified that court can grant compensation to the victims of crime or even victim of violation of fundamental rights. As a part of this, I may say that PIL is very important mode which is available to the advocates for protection of human rights. As an advocate, even I also filed some PILs in Bombay High Court and Apex Court, wherein I tried to vindicate the rights of common people, wherein the state failed to implement the law in its proper perspective. I'll give two examples. The Protection of Women from Domestic Violence Act was enacted in India in 2005. It is a central legislation. So far as Section 37 of that act is concerned, the central government has power to make rules. Accordingly, in October 2006, rules were made. And in October 2006, this particular law came to be implemented in entire India. Now, as advocates are closely connected to law, and as advocates are even closely connected with implementation and interpretation of law, they can play a very important role in implementation of that particular law and even in protection of human rights also. Now, basically, domestic violence law is a human right law because this law has been enacted to protect rights of women in India who are victims of domestic violence. Now, Section 8 and 9 of this act is there, which provides for appointment of protection officer. Now, right from commission of domestic violence till the eradication of that violence, a protection officer has to act as a central authority under the Domestic Violence Act. Now, in 2006, in Maharashtra also, some protection officers were appointed by the state, and they were not full-time protection officers. They were part-time. Some officers of revenue like Tahsildar, block development officer, education officer, they were given additional duties in Maharashtra, and they have to implement that particular law, that is Act of 2005. In 2007 and 8, when their trainings were conducted in state of Maharashtra, it was found that these protection officers are not having time to file cases on behalf of that aggrieved person who is a woman in judicial magistrate first class courts. And because of that, the effective implementation of that particular law has been at stake, and these laws are not enacted, properly implemented in the state of Maharashtra. Because of that, or as a result of that, even we may say that due to appointment of protection officers, we may say additionally, but not appointing them fully or not appointing them on regular basis, the Maharashtra government had failed to protect the human rights of women in Maharashtra. So even I filed one PIL in Bombay High Court, wherein Bombay High Court took very serious view by sending a notice to the government of Maharashtra by saying that as Section 8 of the Domestic Violence Act deals with full-time protection officers, part-time protection officer will not be able to discharge their duties properly. And finally, in 2016-17, full-time protection officers came to be appointed in state of Maharashtra. Now in Maharashtra, if we see for one police station or for one court, that is judicial magistrate first class, one protection officer has been appointed who is a full-time protection officer. and that protection officers were appointed in the wake of decision given by Honorable Bombay High Court in my PIL. Now their training has been conducted, and now they are working in state of Maharashtra as per police station or as per the Judicial Magistrate First Class Court. Now they are filing regularly the domestic incident report in the court as per that form number 1. If any order is passed by the court, then they are even implementing the orders of the court, and they are assisting that particular aggrieved lady to protect her fundamental rights. So as a part of judiciary or as a part of officer of the court, advocate can play very important role because he know what kind of issues are there in implementation of law. So he can do research, he can find out the issues which are there, and he can agitate that particular issues in the court of law by filing the petition. I did that in relation to domestic violence law, and today the fact is that in state of Maharashtra, full-time protection officers are appointed. I will give another example how PIL is an important mode for advocates to implement or protect human rights in India. As we know that there was Juvenile Justice Act in India, which was firstly enacted in 1886. But that Child Right Convention was ratified by United Nations in 1989. This old law of 1986 was not effective, so it was repealed in 2000. In 2000, new law came, that is Juvenile Justice Care and Protection Act of 2000. This Act of 2000 speaks about ultimate rehabilitation and social reintegration of juveniles. Now that law is also repealed by the Parliament of India, and in 2015, now new legislation has come to force. In 2000 Act, there were some provisions wherein in Maharashtra state, not only in Maharashtra, but even in entire India, the government had failed to implement this Juvenile Justice Act effectively. And as a result of that, human rights of juveniles were grossly violated. You know that so far as definition of juvenile in section 2 of that act is concerned, it says that juvenile is a person who is below the age of 18 years. Now, very importantly, as juvenile is a person who is below the age of 18 years, juvenile has been bifurcated by that particular act, has been classified by that particular act in 2 categories. First is a juvenile who is in conflict with law, or a child who is in need of care and protection. Now, 2 categories are there. First is a child who is in need of care and protection, and second is a juvenile who is in conflict with law. That is the definition of child provided by section 2. Now, as far as juveniles are concerned who have committed offences, they can be taken into custody by the police. They can be brought before the Juvenile Justice Board, Child Welfare Committee, and they can be kept in remand home for reformation. But second category is there, that is juvenile or we may say child in need of care and protection. A child in need of care and protection is a person or is a child who has not committed any kind of offense, but who is found to state on street or on any other part, or who is a neglected person. Even a child may be in a home, but he may be neglected by father and mother. In that case also, he can be treated as a child in need of care and protection. In 2012, in only Maharashtra state, there were 84,000 child in need of care and protection. Now, according to Juvenile Justice Act, if a child is in need of care and protection, he can be taken into custody by Child Welfare Committee. He can be produced before that committee, and then he can be sent to children's home. Now, according to the definition of this particular act, a child in need of care and protection can be kept in children's home till he attain or till she attain the age of 18 years. After that, they can be released or they can be discharged from their children's home, because Juvenile Justice Act doesn't take care of those who are above the age of 18 years. Only in the state of Maharashtra in 2012-13, there were 84,000 child in need of care and protection. And in India, when information was obtained by Right to Information Act, it was found that there are more than 21 lakhs child in need of care and protection. Now, these childs who are in need of care and protection. They are not aware about their religion, about their caste, about their parents, and they are regarded as even orphan. And these orphans are not having even right to identity. When they are discharged from the children home, they don't know where to go. They don't have any kind of government document with them like Aadhaar card, like even we may say below poverty line certificate, or no other document was available to them, even domicile certificate also. So in 2010-11, when I came to know this in one seminar, that those orphans who are below the age of 18 years, when they are discharged from the children home, have no place to stay. I filed one RTI application to Women and Child Development Department of State of Maharashtra, wherein I asked some questions as an advocate, that how many juveniles, how many childs are there in state of Maharashtra who are in need of care and protection. So I received the answer, there are 84,000. Second question I asked in RTI, that whether state is providing any education facility to them when they attain the age of 18 years. So answer was in negative. Third question I asked in RTI, that when these childs are discharged from the children home, whether the government is having any kind of data with them, that where they go or where they are residing. So government has answered negatively also in that relation. Fourth question I asked, whether the government is having any kind of scheme for providing any hostel facility to them, any we may say scholarship to them. To that also the answer was in negative. I also ask one question, that whether government is providing them any kind of loan facilities so that they can work on any small scale industry. The answer was also no. And the last question was that what government is doing when they attain the age of 18 years or after that, so far as coordination between various stakeholders are concerned, like police officers, various NGOs are working, various child welfare committees are there. The answer was in negative. And last question which even I asked was that whether government is providing any document to them when they left that particular children home, to which also the answer was in the negative. So I filed one PIL as an advocate, as a public spirited citizen in Supreme Court of India. My petition came to be disposed on same day by Justice Kapadia in courtroom number 1, wherein when he came to know that I have not given representation to all other states, because the court was of the view that this particular issue is very serious. What is happening in the state of Maharashtra is always is there in other state also, because Juvenile Justice Act is a central legislation, and according to court, there shall be some uniform rules in that regard. So court directed me to give representation to all the states in India by redressing these particular issues, which I asked to state of Maharashtra. Accordingly, my petition came to be disposed. I gave representation to all the states in the state of Maharashtra, including 7 union territories. And when I received the information, it was very shocking and surprising that whatever is happening in state of Maharashtra was there in all the states. So opportunity was given to me by Apex Court, by exhausting this particular remedy, to approach again to Supreme Court of India. I exhausted that particular remedy. I again filed a second PIL in Supreme Court after giving opportunity to all the states to redress the issue of Juvenile Justice Act. As they did not take any kind of action, I filed second petition in Supreme Court of India, and on first day of hearing, Supreme Court of India issued notice to all the states, including 7 union territories. When petition came for hearing, 23 states supported my PIL by saying that the issue is of concern and there is a need to form a uniform policy so that Juvenile Justice Act can be effectively implemented in India. Court asked me whether you are willing to prepare that particular policy, to which I answered positively, and some time was given to me by the Apex Court. One policy was framed by me by discussing that particular issue with some advocate friends, and that came to be filed in the Supreme Court of India, wherein the first important aspect which was dealt in that policy was that when a child will leave that particular children home when he will attain the age of 18 years, government shall issue one orphan certificate to that child. Now, what was happened in India was that when the childs were discharged from children home, as they were homeless, as they were not having their own parents, as they were not aware of their even religion and their caste. It was very difficult to sustain them for them in society, as they don't have their own identity. Constitution of India speaks about right to identity, right to nationality, right to dignity, right to life, right to personal liberty. Uh, Unfortunately, all these rights were denied to these orphans in India till the disposal of this case. Because a juvenile or a child who is above the age of 18 years, who is discharged from the children home, was not having even his own identity, was not having even a Aadhaar card, was not having even a BPL certificate with him, or not having even a domicile certificate with him. So after discharge from that particular children home, even if you want to obtain a SIM card of mobile also, he was not able to do so because he was not having his own identity. Even if you want to purchase a SIM card, he has to give some documents which he was not having that time. So my first demand in that scheme was that when these children will be discharged from the children's home, a government shall issue one uh, orphan certificate to them. The second demand was that government shall provide some educational facilities to them, including school fees or even college fees, because they are barely 10 pass when they are discharged from that particular children home. The third demand which I made was that so far as government hostels are concerned, a state shall give them admission in that government hostels by reserving some quota for them. Fourth was that if they want to marry after attaining the majority, then some financial help shall be provided to them. Fifth scheme was that if they want to do some small scale business, then government shall provide some loan to them because they don't have their own base. And another important scheme was that uh, government shall ensure that there will be proper sensitization and awareness of those who are the stakeholders of under this particular act, like police, some NGOs, even the judges, and even the members of child welfare committee. Accordingly, when I filed this particular scheme in the Supreme Court of India, uh, that particular scheme was accepted and approved, and even by even by the central government and all the states. And accordingly, on 9th of August 2015, my petition came to be disposed by the Supreme Court of India. Uh, Very importantly, in Maharashtra, one positive thing was happened after the disposal of this particular petition, which was in my favor. In 2018, uh, on the basis of my petition, because when in my petition, state of Maharashtra file affidavit, in para number 4, it was averred that we are very serious to give 1% reservations to orphan in the state of Maharashtra from OBC category. And when in 2018, I was even called by some government officials, and they again took information of that PIL, including that particular scheme which I filed in the Supreme Court of India. And in 2018, in Legislative Assembly session, the resolution was passed, and 1% reservation came to be given to orphans in the state of Maharashtra. And finally, in 2021, even cabinet also took decision, and now in Maharashtra, on the basis of that PIL, which we file in Supreme Court of India, in 1% reservation is now given to the orphans in government services. Just before 3-4 months in Maharashtra, public prosecutors exams were conducted, wherein 550 posts were there, in which 5 posts were reserved for orphans under that particular category, which is a result of that particular PIL. So the first important aspect is that as far as protection of human rights is concerned, advocate can play a very important role because he is closely connected to law. He can do research. He can find out the issues which are there in the society, and he can agitate that particular issues in the court of law by enforcing rights of those who are aggrieved, who are vulnerable, who are weaker section of the society, or even who are illiterate and who are not able to approach the court. So, as a part of socio-legal practice, an advocate can play a very important role in protection of human rights. Now, second important aspect is there, what the advocate can do even though he has not approached to court for protection of human rights. Even by approaching to court also, he can do that particular activity, and that is a legal aid. This important aspect is also there, mandated by Article 39A of the Constitution. The concept of legal aid has been approved and mandated. But as we know that Article 39A is part of Part 4th of the Constitution, that is Directive Principles of State Policy. And Article 37 says that even though directive principles are fundamental in the governance of our country, they are not enforceable in the court of law. So even though directive principles deals with some basic fundamental rights, still they are not enforceable in the court of law because of Article 37. There is a bar by Article 37 that they are not enforceable in the court of law. Now, very importantly, even in some cases, even Supreme Court had also clarified that for enforcement of directive principles, we cannot issue mandamus. But now the situation has been changed, and now there is a, we may say, transformation of some directive principles into fundamental rights. And now the distinction between Part 3rd and Part 4th has been blurred. And legal aid or legal assistance is one of the part of that. Now, as I said earlier, that Article 39A is part of directive principles of state policy. Article 39A is not enforceable in the court of law because of Article 37, as Article 37 says that even though directive principles are fundamental in the governance of our country, they are not enforceable in the court of law. In 1978, one landmark judgment was given by Apex Court, that is Hoskot versus State of Maharashtra, wherein Apex Court has clarified that right to free legal aid is a fundamental right under Article 21 of the Constitution. Again, in 1978, Husainara Khatun versus State of Bihar was decided, wherein Supreme Court of India has decided that right to free legal aid is a fundamental right. Even in Khatri versus State of Bihar of 1981, Apex Court has clarified that right to free legal aid is a fundamental right. And even Justice Bhagwati has opined in Khatri case that why we should not invent new tools and new remedies for the enforcement of fundamental rights guaranteed by Article 21 of the Constitution of India. And finally, in 1987, Legal Services Authority Act was enacted by the Parliament of India, wherein legal aid can be obtained by poor at the expenses of the state. Now, because of Hoskot versus State of Maharashtra, even Khatri versus State of Bihar, and even Husainara Khatun versus State of Bihar, we can say that Article 39A is now converted in Article 21 of the Constitution. So, what was not enforceable in the court of law because of Article 39A and Article 37 is now enforceable in the court of law because of Article 21, as now right to free legal aid is a fundamental right under Article 21 of the Constitution. So the distinction between Article 21 and Article 39A has now blurred, and we may say that Hoskot versus State of Maharashtra, Husainara Khatun versus State of Bihar, and Khatri versus State of Bihar are bridge builder between Part 3rd and Part 4th of the Constitution. And now, second important aspect is there as a role of advocates, that they can discharge a very effective role in protecting human rights by providing some legal aid to those who are in need. So, besides PIL, even providing legal aid pre-litigation and after litigation is also one of the important aspects which the advocate can discharge. Now, third important aspect is there, which is very important, and advocates have very important role to play in that. I am discussing this particular aspect for the reason that sometimes advocates may deny providing any kind of legal services to those who are accused in any particular crime. This happens particularly when some rape has been committed by any particular accused. Some bar associations are passing a resolution that no one will take wakalatnama on behalf of that particular accused person. For that purpose, if we go to section 49(1)(c) of the Bar Council of India rules, which are framed by Bar Council of India, two important rules I may mention here for today's discussion, wherein advocates have some duties or they have some role to play. The first is that advocate is bound to accept the brief on behalf of any particular accused person unless special circumstances justify refusal to accept. And second is that it is the duty of the advocate to fearlessly uphold the interest of the client. Now, these two rules are there, which are issued by Bar Council of India under Section 49(1)(c) of the Advocates Act 1961. But unfortunately, in India, advocates are denying legal services in some cases to those we may say accused persons who are involved in any particular crime. As I have given example, that in some cases where heinous crime is committed like rape, or there may be sometime offense against the state, wherein resolutions are passed by bar council, by some bars, and they are deciding not to give assistance to that particular we may say accused persons. Now, Article 21 says that no person shall be deprived of his life and personal liberty except according to the procedure established by law. And if we see Article 22, Clause 1 and 2, some important rights are guaranteed by that particular article. Article 22 guarantees, number one, every person who is accused, who is arrested by police, is having right to inform the ground of his arrest. Number two, he is even having right to consult a lawyer of his own choice. Number three, after arrest, he shall be brought before the court within 24 hours, excluding the time of journey. And number four, beyond 24 hours, if his detention is required, then that can be done only by the order of the court. So these are the four fundamental basic freedoms which are guaranteed by Article 22, Clause 1 and 2 of the Constitution. And these are basic, even human rights of that accused persons. When bar councils or bar associations are passing a resolution that they will not defend any particular person, then in that case, there is gross violation of even Article 22 also. Supreme Court of India took cognizance of this particular issue in 2011 in Mohammed versus State of Tamil Nadu case, wherein Supreme Court of India held that if any bar association has passed any resolution that they will not defend any particular criminal in any particular case, then that particular resolution is null and void. That particular resolution is unconstitutional. That particular resolution is illegal. And if such kind of resolutions are issued by any bars, then that is gross violation of constitutional mandate guaranteed by Article 22 Clause 1 and Article 22 of the 21 of the Constitution. So Mohammed versus State of Tamil Nadu is a judgment given by Supreme Court of India in 2011, wherein Supreme Court of India has mandated that it is the duty of the advocate to protect human rights of common people. Even though they are involved in any particular heinous crime, it is the duty of them to provide them legal aid and to implement Article 22 and Article 21 of the Constitution. Even after that, in 2013 also, Vijaya Lakshmi versus State of Andhra Pradesh was decided by Supreme Court of India, wherein Supreme Court had clarified or Supreme Court very clearly laid down that it is the duty of the advocate to defend the accused regardless of his personal opinion about the guilt of that particular accused. So the loyalty of that advocate is to the law, and he has to discharge his duties properly. So this is very important aspect in relation to day-to-day practice, wherein not only in Maharashtra, but even in other part of India also, whenever any heinous crime is committed or any crime is committed, particularly like rape or like sedition, or like now sedition is no there in relation to new legislation which will come after some time. But there are offenses against the state wherein some bars are passing the resolution that they will not defend that particular criminal. So when police are arresting that particular person and when he was brought before the court for remand, no one is appearing for that particular accused person, as a result of which he is remanded to police custody for 15 days because CBI versus Anupam Kulkarni of 1994 is saying that remand cannot be there for more than 15 days or PCR cannot be there for more than 15 days. But after that, he is sent to magistrate custody or jail. As a proper legal service is not available to him, he is not able to apply before the court for bail also, and because of which his basic fundamental freedom, that is right to life and personal liberty, is grossly violated. So this is very important aspect wherein Muhammad versus state of Tamil Nadu and Vijayalakshmi versus state of Andhra Pradesh are to be remembered by the members of legal profession, and they should be able to protect the fundamental rights of even those who are involved in crime in absence of any particular resolutions which are passed by the bar. Because bar has no right to pass such a resolution is clarified by Apex Court, and if such resolutions are passed, then Apex Court is saying that they are null and void. Fourth important aspect is there, which I want to elaborate as a part of advocates' duty to protect human rights or role of the advocate to protect human right. That is, advocate can be a part of any particular NGO, that is non-governmental organizations, and he can discharge very effective role in protecting human rights of common people. There are several examples in India, like Lawyers Collective of Honorable Indra Jaising, or even HRLN of Advocate Colin Gonsalves, wherein they are working for protection of human rights as a part of social legal practice, and we can also do so. So very importantly in India, as a part of criminal justice system, as advocate is morely connected to law than other member of the society. Any public spirited advocate can work very effectively in protecting the human rights of common people, and by providing even the legal help to them. I am thankful to MANIKCHAND PAHADE Law College and basically Dr. Aparna Kotapalle Madam for giving me an opportunity to discuss the role of advocates in protecting human rights. Thank you very much.
Thank you, Dr. Rajendra. Thank you for being with us, and thank you for guiding the participants on it. Now, there are a few questions that are being placed in the chat box. So if you permit, and others,
Yes, please.
if you are willing to pose some questions, you are free to place it in the chat box. And those participants who are willing to give the feedback about the whole organization of this seminar, you are most welcome. 3 to 4 participants, we wish you must, rather, if you give your feedback, that would be certainly valuable to us. Any questions from your side? You can unmute yourself and you can ask, or else you can place it in the chat box. Okay, names for the expressions are coming, and they have given feedback also. Like, okay, wait. The technical team, I would request you to please unmute Mr. Sachin Shewale. Mr. Shivkumar sir, are there any questions in the chat box? Please see to it.
No, ma'am, just people willing to give feedback about the event.
Okay.
Let's call one by one.
Yes.
May I, ma'am?
Sure, sir.
Before proceeding with the expressions, let me personally and on behalf of the Institute thank Dr. Anbule sir for being with us. And over to you, Shivkumar sir.
Thank you so much. Thank you so much, ma'am. Sir, there is one question from Ms. Amulya Raj. He's asking, whereas government is not very much active about rights about orphans, is there anything we can do for them as a growing society regarding rights of the orphans?
Yes, I have experienced this particular aspect that whenever there is question of implementation of social legislations, it may be a Juvenile Justice Act or any other act, government is always coming with the defense that they don't have budgetary provisions. And if proper budget is not there for implementation of the act, then that particular law fails. Because provision of the act may be very, we may say, important for protecting human rights of that particular orphan or any other, we may say, subject. But at the same time, if government is not providing a proper machinery or proper facilities for implementation of that particular, we may say, right, then in that case, that legislation is of no use. So in social legislations, the fact is that government is always, we may say, unwilling to provide financial help or proper funds. But as a public spirited citizen or as an advocate, as I said earlier, that we can file PIL in Supreme Court or High Court. We can take directions from the court. And if government is also not obeying the directions of the court, then we can go for contempt. In some cases, even in my case also, I filed PIL in Bombay High Court in 2012 for implementation of domestic violence law. Protection officers are appointed in 2016, but till today my petition is not disposed by the court because Bombay High Court said that we want to exercise continuing mandamus in this case. We want to supervise the work of the government, that how they are doing. So we can direct the court not to dispose the petition and ask to supervise the government. In that case also, government can then implement that particular laws effectively. So proper thing is that for implementation of laws, we have to be cautious. If government is not serious, then we can go for contempt, or even we can ask the court not to dispose the petition and to supervise the work and take appropriate decisions at appropriate point of time, or appropriate directions at appropriate point of time. That is the proper way to go for implementation.
Thank you, sir. I would like to invite Dr. Amit Singh to say a few words about the event.
Thank you very much, the organizers, to organize this event. I'm pleased to listen to all the discussions done right from beginning by Honorable Justice Sadhana Jadhav ma'am, Madam from Christ University, and Mr. Dr. Rajendra ji. I think it's a very, very important event to celebrate, even if we see a lot of injustices all around. But I think importance lies in celebrating whatever we could contribute. As Honorable Justice Sadhana pointed out, we should stand in solidarity for human rights of each of people on planet Earth. And I am privileged to be part of the discussion. Thank you, everyone.
Thank you so much, sir. Next, we have Ms. Shraddha Kapatne. Ma'am, are you there? Okay. Next, we have Mr. Sachin Chevale Patil.
So, Kumar.
Yes, sir.
Pahade asked for unmuting.
I'll forward it to technical.
Good afternoon, sir, and good afternoon to the dignitaries. I would like to thank Mr. Rajendra, Advocate Dr. Rajendra Anagule, sir, and Justice Ms. Sadhana Jadhav ma'am and the Dev ma'am also. They have given with some important message on the occasion of the Human Rights Day and boosted us up to perform our duty as a lawyer, as we are the crucial part of the society, and to encourage the feeling of the Vasudhaiva Kutumbakam, as we all feel, as the whole earth is a family. And on the occasion of Human Rights Day, I feel glad to part of this event, and I am thankful to the organizers as well as Kotaballe ma'am and Dr. More sir to make all of us the part of this event. Thank you.
Okay. Mr. Sachin Shivale Patil.
Jai Hind, sir. Thank you for giving opportunity to say something about this seminar. Thank you for the organizers to arrange this kind great lecture to us by Advocate Dr. Rajendra sir. Respective Rajendra sir, you had mentioned one policy for juveniles you had made by your petition, and I would like to mention here is a juvenile school organized by Padma Shri Dr. Girish Prabhune at Chinchwad, Pune. That is Samrastha Gurukulam. They are providing the basic skills for day-to-day life to that juveniles for the helping them above after getting the age of 18 and getting major in society, they can survive for themselves. And your great initiative is very good for us. Thank you, sir.
Thank you so much, sir, for your kind words. Now I would like to request our principal, sir, to deliver the valedictory address.
Respected participants, it is the end of the session. There is no need of valedictory because of the overwhelming response from the faculty and students. We have decided from next January, we are going to have physical program either on Saturday or Sunday, 1 hour with different luminaries on the legal expertise for the benefit of students on different angles of social, legal issues which are concerned with the society. And on this particular occasion, I congratulate Aparna Kottapalle and her team of my colleagues and her colleagues for doing a wonderful job highlighting awareness among the society through this particular academic feast for the benefit of legal fraternity. Thank you, one and all.
Thank you so much, sir. Now I would like to request Mr. Hemant More, sir, to deliver vote of thanks for the session.
Good morning to everyone. Today I feel incredibly honored and privileged to have been allowed to extend a vote of thanks on behalf of MP Law College. I extend my gratitude to our Honorable Resource Person, Advocate Dr. Rajendra Ambule sir, to take out time from his busy schedule to grace the event. Thank you for knowing our role in protecting human rights. Your work regarding the juvenile is inspire us. I thanks Dr. Sampadev ma'am also. I also thanks our chief guest, Honorable Justice Srimati Sadhna Jadhav ma'am. A special thanks to Dr. C.M. Rao, Principal of MP Law College, and Vice Principal Mr. S.N. More sir for providing such an immense support to make this seminar successful. I am thankful to IQAC coordinator Dr. Aparna Kottapalle ma'am for organizing the seminar. I also thank senior faculty members, also Amruta ma'am, Uma Shinde ma'am, and Mr. Shiv Kumar sir for anchoring this session. I thank technical team also. At last, I must thank all the participants from college and outside the college for their active participation. Thank you everyone once again making it happen. Thank you to all.
Thank you so much, sir. Participants are requested to fill the feedback form. The link is I'm posting the link here for your perusal. please ensure that you fill this form. It is very much significant for us as it gives importance about the event. With that disclosed, I would like to request our principal sir to finally conclude the event.
The event is concluded.
Thank you so much, sir.